Hey guys, question of the day for everybody is, was Tyrone Blackburn defamed by Joseph Tacopina? Now, last time we got together to talk about anything related to Tyrone Blackburn in the context of the Fat Joe, Terrance Dixon back and forth cases, was back and forth sanctions motions. And I left off saying, look, we're going to do a stream. We're going to look at these defamation lawsuits that Tyrone Blackburn filed against multiple parties. 3 separate lawsuits that came in towards the end of June. The main one we're going to focus on today is against Joe Tacopina and his law firm. And it relates to statements that Joseph Tacopina made claiming that Tyrone Blackburn ran over a process server who was trying to serve him the complaint in the Fat Joe case. So, we didn't get to do a live stream quite yet looking at the full complaint filed by Tyrone Blackburn. Joe Tacopina filed a motion to dismiss under anti-SLAPP. And in that filing, he included a folder of exhibits. So we've got a lot to digest, So as we go through this, you guys, you be the judge. You decide, do you think Tyrone Blackburn was defamed by Joseph Tacopina? Now, this was ... /star that brought this to my attention. So big shout out to ... /star. And we're going to start with what I think everyone's going to want to see first. These 2 exhibits, they're short clips. One's 19 seconds, the other's like 30-something seconds. Are videos from the 2 individuals that went to serve these papers to Tyrone Blackburn. These videos became the subject of the criminal prosecution that at this point in time is dismissed against Tyrone Blackburn. Here we go. Let's see with our own eyes.
Do you want to do it now?
Sorry. All right, Tyrone. Tyrone, you're served. Take the finger. Here. Tyrone, you're served. Tyrone.
Put on the windshield.
Whoa.
Do you want to do it now?
All right, so we're going to play it twice, but you hear that whoa at the end. You also hear some beeping, which sounds to me like the vehicle may be registering that something's behind it. Let's watch it twice.
Do you want to do it now?
Sorry. All right, Tyrone. Tyrone, you're served. Take the finger. Here. Tyrone, you're served. Tyrone.
Put on the windshield.
Whoa.
Do you want to do it now?
All right, and then the second clip, after we hear that whoa at the end.
Salt, you're served.
Now, does that look like the process server was actually hit by the vehicle? Just gonna let that marinate a little bit right there. To me, that's what it looks like.
Let's go.
Served.
All right?
Take the off.
Yeah.
And then he's driving away. Now, another thing I want to point out is Tyrone Blackburn has said that he drove away because he wasn't aware who these individuals were. When you are aware that you have struck somebody with your vehicle, you're supposed to stop. You're supposed to not just drive away from an accident. And Tyrone Blackburn claimed that he was afraid. He was in fear. He didn't know who these individuals were. And because he faces threats in the course of his work advocating for victims of sexual assault, he believed that it could have been someone following him home to like harass him over the Diddy case, in relation to the Diddy cases. So here, I think once you have this video footage, you can't pretend you didn't see the individuals, because he's looking at them. It seems like he's motioning towards them. Even before he pulls out of the driveway, you could see him looking out the window. So I think that could explain, either it's a genuine answer, it's a genuine explanation, or it's a, hey, based on what's available in this video evidence, I have to come up with an excuse that fits the facts. So you guys can make up your mind what you think there. I personally think it's a joke. He knew he hit somebody. The vantage point of this guy's leg is within the line of sight of where he's looking. It seems like he's looking down at the leg like, oh, geesh, Look at his face. So I don't think there's any reasonable way to claim that you were unaware that you just struck somebody, especially with the vehicle beeping. And this video footage to me is so critical because when I'm listening to Tyrone Blackburn explain something, sometimes I'm like, I don't find myself ready and willing to believe Tyrone Blackburn. But sometimes his stories and his explanations are so detailed that I'm like, okay, well, would he really go this far with a lie? And so to see this video, I think is important. And I'm not the one, this is all about Joe Tacopina. And why it's relevant for what we're going to discuss today is Joe Tacopina is saying, I saw these videos before I gave statements to TMZ. The statements I gave to TMZ, they are the subject. They are the heart of what Tyrone Blackburn is now saying is a defamatory, it's a knowingly false statement, and I knew it was false when I made it. But I relied on these videos. So if I say, Tacopina is saying, if I say that Tyrone Blackburn ran over a process server because he wanted to avoid service, and I'm aware of this video footage, I've already observed this video footage, and I've seen the injury on the process server's leg, is it reasonable for me to draw the conclusion that Tyrone Blackburn ran over the process server? And I wholeheartedly think, yes, that's a reasonable statement to make. It's a reasonable belief based on the information you've observed. But that's the heart of the defamation claim against Joe Tacopina. So we're going to get into Joe Tacopina's response. But because we didn't have a chance to do the stream on the complaints, which it's a lot altogether, I do want to read the language as written by Tyrone Blackburn. So this one was filed on June 24th. This is against Tacopina and his law firms. And he's saying that these actions here, we'll read like 5-10 pages of this. This action arises from a calculated, premeditated, and malicious multi-platform media campaign orchestrated by Joseph Tacopina, opposing counsel in active civil litigation against plaintiff. Because remember, Tyrone Blackburn is a defendant in the Fat Joe case. To brand plaintiff across national television, print media, wire services, and social media as a violent criminal. A lawyer who deliberately drove his car into a 66-year-old man and committed felony assault. Those accusations were false when made, continued after plaintiff's arrest, and have now been rejected by every legal tribunal to examine them. This complaint is deliberately confined, and I want to make it clear. The dismissal in the criminal case, we looked at that order and some of the surrounding issues on a different stream, on an earlier stream, 2 or 3 streams ago. That wasn't a merits-based decision. It was an issue with the way that the prosecution from the district attorney's office, the way they presented certain witnesses and certain lines of questioning in front of the grand jury. So to stretch that dismissal on that basis with the implication that the merits have been rejected, I don't think that's a good faith characterization, my opinion. They say this complaint is deliberately confined to a discrete and provable category of false statements. Tacopina's factual assertions that plaintiff A, intentionally struck a process server with his vehicle, and B, thereby committed felony or vehicular assault. Each statement is an assertion of objectively verifiable fact about a specific event and specific crime, not a characterization, an opinion, or a report of any judicial proceeding, and each has been disproven by the dismissal of the indictment and the subsequent no true bill. Plaintiff does not sue upon and expressly excludes from the causes of action below any statement that constitutes an allegation made in or a fair and true report of any judicial proceeding. In addition to the felony assault statements, the YouTube publication contains an independent false statement of professional incompetence that plaintiff didn't vet these claims at all before filing the lawsuit, which is separately actionable as defamation per se, as a statement injurious to plaintiff in his profession. Now that's true. When you say like a lawyer's unethical or whatever, it's defamation per se. If it's not the truth, right? If you can't back it up, because it's involving something that's like inherently injurious. But the issue here, what comes to mind for me, is before this Fat Joe lawsuit was filed last year, that wasn't the first time I'd seen a discussion about Tyrone Blackburn. And it makes me wonder, does Tyrone Blackburn have much of a reputation, if any, for such a statement, if it's not even true, to cause any more damage than what other harm might have been done based on people's perception, awareness of any of the other acts, interviews, cases, litigation that Tyrone Blackburn has been a part of. So there's layers here that go beyond the bubble of the Fat Joe case. They say Tacopina's defamatory felony assault campaign did not arise in isolation. Beginning on or about April 29th, 2025, this is when we have the initial filing of the Fat Joe defamation lawsuit against Terrance Dixon, Tyrone Blackburn, and Tyrone Blackburn's law firm. Contemporaneously with filing a civil action against plaintiff on behalf of his client, Tacopina launched a sustained press offensive characterizing plaintiff to the media as an extortionist, months before any arrest, charge, or indictment. That pre-arrest press campaign is pleaded herein not as an independent cause of action, but as direct evidence of the premeditation, motive, and actual malice with which Tacopina later published the false felony assault statements, on which this action rests. On June 25th, 2025, the same day plaintiff was arrested for this charge with the process server, Tacopina escalated his campaign by appearing on live national television broadcast and making and causing to be published additional false statements of fact that a 66-year-old man didn't want to be served, so plaintiff took his car and ran into him. Well, I think the 66-year-old man was about the server, not the person who didn't want to be served, but okay. Did something help him write this and it got confused about the attribution? And then plaintiff had committed felony assault. Tacopina's TMZ live appearance occurred while plaintiff was still in NYPD custody at the 69th Precinct in Brooklyn, and before plaintiff had been fingerprinted, photographed, formally booked, arraigned, or otherwise processed into the criminal justice system. Meaning that, at the moment Tacopina was telling a national television audience that plaintiff had committed felony assault and taken his car and ran into a 66-year-old man, plaintiff had not yet been charged with any crime by any prosecutor or court. When the host hedged the accusation with the word allegedly, Tacopina instructed him on air to, you could take allegedly out of that question, converting a hedged report into an unqualified assertion of fact. Tacopina's accusations were not hedged predictions or rhetorical flourishes. They were specific, concrete, factual assertions that a particular man, on a particular date, intentionally drove a vehicle into a particular victim and thereby committed a particular crime. Such statements are provably true or false, and they are false. And then on May 26, 2026, the Honorable Dale Fong Frederick, acting Justice of the Supreme Court of the State of New York, Kings County, dismissed the indictment against plaintiff on the grounds that the prosecution engaged in pervasive and prejudicial misconduct during the grand jury proceedings that undermined their duty of fair dealing and may have impaired the grand jury's fact-finding process. The court further held that the prosecution misrepresented service of process law, falsely suggesting that the traditional way to serve process is to hand papers and say you've been served, which is not the law in New York State. On June 22, 2026, after the Kings County District Attorney elected to represent the matter to the new grand jury, that grand jury, independent of the prior defective proceeding, hearing the people's evidence on its own terms after the prosecution had every opportunity to cure the defects, returned a no true bill, so declining to indict. As a matter of law and historical record, no criminal charges remain pending against plaintiff. The factual narrative on which defendants built their nationwide campaign, that makes me think of the nationwide insurance jingle, the plaintiff deliberately, intentionally, and unlawfully drove a vehicle into a process server and committed felony assault, has now been rejected by every legal tribunal that has examined it. First, by the Supreme Court of the State of New York. And remember, guys, in New York, the Supreme Court in New York is not the highest court in the state. It's the trial court. They just have their own weird naming schematic that doesn't comport with how every other state seems to name their courts. So Supreme Court of New York is a trial court. on a finding of prosecutorial misconduct, and second, by an independent grand jury that found insufficient evidence even to indict. Despite that dismissal order, and despite the June 22nd no true bill, defendants have published no correction, no retraction, and no clarification of any of the false and defamatory statements they made or caused to be published. Defendants' statements remain in active circulation in the public domain through their original publishers, through derivative republications, and through search engines and digital archives, continuing to injure plaintiff each day they remain uncorrected. Now, again, there are 3 different lawsuits filed. This one just deals with Tacopina, the law firm. So I'm not really sure Tacopina is responsible for, like, taking down an article. Like, maybe he could go out of his way to ask. But is to leave something published the fault of a non-publisher? And it just makes me wonder if this was like, I wonder if we'd see the same exact language from one of the other lawsuits, maybe against TMZ. And this is kind of just like copy pasted in and not really adjusted for the specific party here. like maybe Tacopina hasn't come out and stated on his own account somewhere, hey, I was wrong about this thing I said previously. Cool, you can gripe about that. But to me, this is worded as if it was meant for the publishers themselves. But whatever. And then Tacopina retained James Hunt to surveil plaintiff and to serve process on plaintiff at plaintiff's Brooklyn home. Hunt is identified in the grand jury record as a private investigator, and on information and belief, was licensed neither as a private investigator with the New York Department of State, as required by General Business Law Section 70, nor as a process server with the New York City Department of Consumer and Worker Protection, as required by New York City Admin Code Section 20-403. Tacopina, a practicing New York attorney, knew or should have known Hunt was doubly unlicensed, yet dispatched him to stake out and confront plaintiff at plaintiff's home after plaintiff had already been served at least 4 times in the underlying litigation and had affirmatively agreed to waive further service. Now, Blackburn has complained in other proceedings claiming that email service isn't enough. So the idea that somebody would want to serve somebody in person just to be extra sure that they got it, maybe it seems unusual when you're dealing with an attorney. You would think that an attorney, you could take them at their word that they're agreeing to accept service by like a digital communication. But I think the circumstances surrounding Tyrone Blackburn, I think it's reasonable to believe you have to serve him in person. Just me. Because service was already complete and waived, the dispatch of an unlicensed investigator served no legitimate purpose and was undertaken in bad faith for the sole purpose of intimidating and harassing plaintiff. All right, so then there we go. That's a little bit of background on Blackburn's position of the defamatory actions of what he's saying Tacopina and his law firm engaged in that was defamatory. Jumping over to the recent updates, and thank you again, /star for the link to the documents. This is linked in the description if you want to go and browse yourself. So we have confirmation of service. I wonder how it was served. Was it served by email? And then we have notice of motion to dismiss with prejudice. So we're really going to get into these exhibits more so. But real quick, and this was filed yesterday, please take notice that upon the affirmation of Peter Bigging, I don't know, and the exhibits referenced there too, the affirmation of Joe Tacopina, the affirmation of James Hunt, that's the process server, and the exhibits annexed there too, and the memorandum of law of Peter, we're going to call him Peter B. Defendants Joe Tacopina, Siegel trial lawyers, doing business as Siegel and DiOrio, by and through their attorneys, will move in the Supreme Court, Kings County, for an order pursuant to civil practice law and Section 70A and 76A of the New York Civil Rights Law dismissing plaintiff's complaint in the above captioned action in its entirety with prejudice, and 2, granting defendants their costs, reasonable attorney's fees, and compensatory damages for violation of New York's anti-SLAPP law. Right? And granting defendants such other and further relief as the court deems just and proper. And then please take further notice that pursuant to Section 2214B, answering affidavits or cross motion, if any, are required to be served upon the undersigned at least 7 days before the return date of this motion. So signed off by Peter B. Let's get to the memorandum. Let's get to the memorandum of law. Where is it? Do we have it? Oh, there we go. It's all the way down here. And also, before we do that, I did a quick scan of like the exhibits. There's like 24 exhibits or something here. I don't know. It's a lot of exhibits. So many exhibits. But we've got like the sanctions order included. We've got deposition transcript excerpts. We've got, what else do we got? I know one of the other cases made it in here somewhere. Opinion and order from Denise Coate. I think that's one of the Diddy cases where it's a court having admonishments of Tyrone Blackburn. And we keep seeing these same decisions referenced anytime somebody's writing a motion for sanctions against Tyrone Blackburn. These decisions from other judges like Denise Coate or Judge Paul Otkin keep making their way back in circulation. We've got the docket from, this is that DJ Academics case with Abashi Fazaya. Fazaya is represented by Tyrone Blackburn. I believe additional counsel might have filed notice of appearance in this case at this point. I've got to double check on this. It's been a minute since I've refreshed on this case. But he represented Fazaya, I think still presently, but at least through the initial stages of this lawsuit. And it was recently dismissed without prejudice because of failure to comply with discovery deadlines. So, oops. And all these different things, plus some correspondence from the early stages that gave rise to Fat Joe's lawsuit against Terrance Dixon and Tyrone Blackburn. Let's get to this memorandum of law. As we go through that, we'll pop over to the relevant exhibits. Unless it's, for example, if one of the exhibits is like the complaint, the long complaint, we're not going to go and read through the complaint on this stream. We'll just know that that's what's being discussed. And let's see. Here we go. Make this bigger, move myself, and get you guys on the screen. How you guys doing? Make you taller. Also, I see some pink here celebrating here. Some 5 gifted from Sheriff Chuck. Holy moly, let me go up and find it so I can pull it on the screen. Thank you, Sheriff Chuck. Hitting us all like process servers. Just kidding. Just kidding. We are not trying to avoid service in this chat. Oh, goodness. My goodness, you guys. If I pause to like take extra drinks today, it's Coke Zero. My throat I've been losing my voice something crazy for the last week. So we're going to try to read what we can. We're going to look at some exhibits. We might not read everything on the stream, but we're going to get the meat and potatoes. So we'll skip the index, all this case law. I see, look at this. We have the Jakes v. Youngblood and Jones v. Combs. So we're going to they're incorporating this other like disciplinary wording from other judges into this filing. They always make an appearance. All right, so here we go. This action is a prime example of a strategic lawsuit against public participation. Slap. We don't want anti-slap. Plaintiff Tyrone Blackburn, I'm just going to call him Plaintiff or Blackburn, is an attorney who's notorious for commencing frivolous actions in federal courts in the hopes that the defendants will agree to a quick settlement. Now, can you just state this about somebody without a basis? I could see an argument that could be defamation per se to accuse an attorney of just like engaging in frivolous actions. Especially if he's charging a client to do so. No bueno. But if there's a basis for it, if there's a basis for you to think that that's a true claim, such as court findings, where other judges have said, What are you doing? Is it defamatory for you to say such a thing? For you to say that Tyrone Blackburn is notorious for commencing frivolous actions in federal court in the hopes that the defendants will agree to a quick settlement? So right here, following this, we're in the preliminary statement, and we go straight to the opinion and order from the Honorable Denise Coate of the Southern District of New York in the action entitled Alexander Zinzorowski versus Leanne Fisher. Right? And it's saying, where the court expressly noted that, quote, a reasonable inference from Blackburn's pattern of behavior is that he improperly files cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressure defendants to settle quickly. So this is coming directly from a judge's words in it's the court's finding. One of his more recent high-profile lawsuits was brought on behalf of his client Terrance Dixon against Joseph Cartagena, who is professionally known as Fat Joe, a successful musician and entrepreneur. Now, we've got a footnote here that says that case is titled Terrance Dixon, aka TA, versus Joseph Antonio Cartagena, let's see, professionally known as Fat Joe. And they're going to call it the Dixon action, okay? So when we say the Dixon action, that is the June 2025 complaint filed by Terrance Dixon against Fat Joe and Sneakers Inc. and Rock Nation and Erica Morera, Pistol Pete. And remember, that was filed after Fat Joe filed his complaint against Terrance Dixon and Tyrone Blackburn. So Dixon action refers to the June action. Justifiably concerned with what he viewed as dangerously false and frivolous allegations being made against him, Cartagena retained defendants, that's he's referring to Tacopina and his law firm, who commenced an action against Dixon and plaintiff entitled Joseph Cartagena v. Terrance Dixon, Tyrone Blackburn, and T.A. Blackburn Law, PLLC. They're going to call it the Cartagena action, asserting claims of defamation and intentional infliction of emotional distress. In an effort to effect service of process of the summons and amended complaint upon plaintiff. Reed Smith, different law firm also representing Cartagena, but it's not Tacopina's law firm, which was acting as of counsel to the TSD firm, contracted with Guidepost Solutions to send a process server out to plaintiff's home to make personal service upon him. Guidepost thereupon instructed James Hunt, Mr. Hunt, to personally serve plaintiff, who was in his vehicle sitting in his driveway when Hunt approached him. Now, remember we have these 3 defamation lawsuits filed by Tyrone Blackburn. The one that we're reading right now, or the one that we just read before this, was specifically directed towards Tacopina. And here we have a little bit more context here where, it's not just Tacopina saying, you know what, here's this sketchy process server. He's unlicensed. I know he's unlicensed. I know his company doesn't have a license. I know that this is no bueno. And I'm going to send him to intimidate Tyrone Blackburn. I'm going to send him to intimidate Tyrone Blackburn. Which, not for nothing, do you need to use a process server to do that? You couldn't find somebody else? like it's just an odd claim. It's just an odd claim. I think it's just an odd claim. But here we're laying out that context, I would say, for the purpose of addressing that. So they say as video evidence of what unfolded next reveals. Plaintiff proceeded to drive his vehicle in reverse and back out of the driveway. But in doing so, he struck Mr. Hunt, causing a gash in his left leg. Based on this conduct, plaintiff was later arrested and charged with, inter alia, 2nd and 3rd degree assault. Given the notoriety of the Cartagena action and the impact that plaintiff's arrest was expected to have, Tacopina agreed to have an interview with TMZ the same day, during the course of which he made several truthful statements. The truth is an absolute defense. And otherwise offered opinions regarding both plaintiff's arrest and his general conduct regarding the Cartagena action, including that plaintiff, quote, took his car and ran into him, a statement that is supported by the video evidence of the incident. This fact notwithstanding, and the fact that his statements were in any event absolutely privileged as an accurate report of an ongoing legal proceeding, plaintiff has chosen to pursue a number of defamation claims against Tacopina and TSD, along with claims for tortious interference with an existing client relationship, 2, negligence per se, 3, trespass to land, 4, negligent hiring, retention and supervision, and 5, violations of New York City Administrative Code 20.4092. Because a review of the relevant documentary evidence reveals that the statements made by Tacopina are true, or otherwise amounting to an actionable opinion, because plaintiff has failed to adequately allege actual malice in connection with any communications made by defendants, and because defendants' communications are otherwise protected by Civil Rights Law, Section 74, the defamation claims in the complaint are fatally defective and must be dismissed. And in connection with the dismissal, an award of attorney's fees and damages should issue pursuant to Civil Rights Law 70A1A, B, and C. And a review of the remaining claims reveal that they must be dismissed based on the documentary evidence or because the claims are otherwise inactionable as a matter of law. So let's get through. Statement of facts. Missed you too, Audrey's fake accent. Thank you for being a member for 10 months. Cat, missed your face. Missed all y'all's faces. I miss you guys too. I like don't love not going live to talk about cases. But last week I thought I just like lost my voice after we did a really long stream in the Zach Adams case. Unfortunately, a disappointing decision from Judge Bradbury. And like later that night, like out of nowhere, like it was like 2 hours later, suddenly like my nose just started like running. And I got like this headache and I'm like, oh, it's because I was talking all day. And then I woke up in the morning and I felt completely fine. And that would have been Sunday. I was doing like housework, just like cleaning, dishes. And I felt exhausted after routine, what I normally do on a Sunday. I felt exhausted. So I'm like, all right, I'm going to take it easy. Monday, thought I felt better, started to do stuff, felt fatigued again. So I don't know, something's just been kicking my butt for the last week or so. So I miss you guys. I miss you guys a lot. And I was not going to miss this live. I also do not plan to miss the Courtney Clenny, the motions hearings. We're finally getting substantive motions hearing in the Courtney Clenny, the OnlyFans murder case, on Thursday and Friday. And luckily for that, the court will be talking, so I won't have to do much talking. But it's been hard. So I'm like, okay, I don't want to go live. I don't want to get stuck talking too much because I don't know what it is, but I overdid it or something. So I've been missing you guys a lot this week, and seeing this absolutely was like something I could not just do as a standalone video. So it's my excuse to come hang out with you guys. I'm so glad you guys are excited to be here too. Thank you for spending your time with me. Thank you for spending the time. Oh my goodness. Thank you, Candace, for being glad I'm better. I'm glad to be here. Oh, Moses says hiring Chuck to serve papers. Yeah, I don't think it was COVID. I mean, after that first like weird like 2 hours after the stream where I thought it was just like maybe my body was like, "Why is your voice so dry? You've been talking too much. What's going on? Let's like flush it out." That's kind of how I saw it, and I never had after that I wasn't getting like any congestion, cough, anything like that. It was just fatigue. It was really, really, really weird. Really, really weird. So, usually when I feel like I'm getting hit by a train, I get like all of the flu symptoms when I have that kind of sickness. And then I gotta wait my 3 days and then it goes away. So I don't know what it was. And I didn't really want to like post like, hey guys, I'm sick. Cause I was like, what? I don't know if I actually am. So Sheriff Chuck says everyone gets served, just don't run over me. YS Kells with the kind reminder, hit that like button, gang. Please hit that like button. Super awesome. Shauna says, the more court cases I hear in New York, there appears to be some controversy of the mind as whether they are attorneys or they're actually criminals. It's just, we got a lot of drama there. And I would imagine, a lot of reason to be litigious in that area, especially like New York City concentrated area. There's a lot of money. So, and money can lead to people doing unreasonable and potentially unlawful things. So, hey, Lady Di says, I don't know anything about this. Look, basically, there is an attorney that his name's Tyrone Blackburn. There are several cases where online opinion, other attorneys, even judges have had concerns about the way this individual, as an attorney, files lawsuits, represents, or has a lack of representation for his clients. And recently, this attorney decided to file three separate lawsuits, all stemming from like the same transactional accusation, really, where he was accused, this attorney, Tyrone Blackburn, was accused of hitting a process server with his vehicle in an attempt to avoid service in one of the cases where he's a defendant in one regard, in one of the cases, but his client filed a lawsuit of his own that I kind of just call a counterclaim back at the same party, the rapper Fat Joe. So it's so much. It's like so much. You don't need to know more than that. But just know that this is Joseph Tacopina. If you watch the ASAP Rocky trial, that's his attorney, Joseph Tacopina. Uh, and actually, there's a deadline in the Relly and Tacopina defamation case today just for the parties to file, I think, like case management information. So we could check for a docket update before the end of the stream on what's going on with ASAP Rocky, Relly, and Joe Tacopina over there. But if you guys remember the ASAP Rocky trial, when I say Tacopina, that's who I'm talking about. So, but here we go. Glad you're here. Glad you're here. This is the motion to dismiss filed by Tacopina saying, like, look, this isn't defamation. We want this dismissed with prejudice because it's really just a strategy by Tyrone Blackburn to stifle, silence, and chill public participation. It's also based on statements that video evidence shows is true, or it's about inactionable opinion, right? So we're just reading the arguments here and looking at the new exhibits, which shed some light on some stuff. If you missed the beginning, rewind and check out the process server video footage. All right, so the standard review here, when it comes to 3211A7, on a motion to dismiss for failure to state a cause of action, the court must afford the pleading a liberal construction, accept all facts as alleged in the pleading to be true, accord the plaintiff the benefit of every possible inference, and determine only whether the facts as alleged fit within any cognizable legal theory. All right, so they're citing the standards here. They're talking about the standards. However, allegations consisting of bare legal conclusions as well as factual claims flatly contradicted by evidence are not entitled to any such consideration. So what we have to see Tacopina do in a motion like this is establish, one, that it's just bare legal conclusions, or that it's just flatly contradicted. The claims are just obviously contradicted by something that's, kind of undisputable evidence. These allegations of the pleading cannot be vague and conclusory, but must contain sufficiently particularized allegations from which cognizable cause of action reasonably could be found. And if the court considers evidentiary material, the criterion then becomes whether the proponent of the pleading has a cause of action, not whether he or she has stated one. On a motion to dismiss, pursuant to 3211A1, the defendant bears the burden of demonstrating that the documentary evidence conclusively resolves all factual issues and that the plaintiff's claims fail as a matter of law. However, while a complaint is to be construed in favor of the plaintiff, the court's not required to accept factual allegations that are plainly contradicted by the documentary evidence or legal conclusions that are not supported based upon the undisputed facts. So what do you think we're going to look at here? those videos, the photo of the injury on the process server's leg. Because again, the heart of the defamatory statements is he ran over, well, I guess Tyrone Blackburn's framing it as he intentionally ran over, right? I mean, if you're saying you drove away because you were afraid that somebody was trying to follow you home from the Diddy cases, even your explanation supports the intentional characterization. And even so, I would argue that the intentional could be an opinion. Could be true, could be an opinion. It could be provably true. I don't think it could be provably false, but I think it could be provably true. like, I don't know. I don't know. So those videos are going to do a lot of heavy lifting here, I think. Because what do you see with your own eyes? So you've got 3211G. Provides that in cases involving public participation, a motion to dismiss shall be granted unless the party responding to the motion demonstrates that the cause of action has a substantial basis in law or is supported by a substantial argument for an extension, modification, or reversal of existing law. This substantial basis requirement is more stringent for the non-moving party to meet than the usual motion to dismiss standard. So this is dealing with anti-SLAPP and why, anti-SLAPP is kind of like a buttress to protect, whereas without any anti-SLAPP public participation, it's on the defendant to show, like, look, undisputably, there's something in the evidentiary that's undisputed and it goes against the stated causes of action. And then the judge can weigh in and say, just because it's stated, I don't have to take it at face value because this factual evidence right in front of me, this documentary evidence right in front of me, shows the exact opposite. So I can then weigh in on that and not just accept the complaint by Tyrone Blackburn at face value. When you involve public participation, when you involve an anti-SLAPP claim, it kind of changes the thresholds. So here, the non-moving party, remember this motion to dismiss is being brought by Tacopina. So the non-moving party would be Tyrone Blackburn. So the substantial basis that Tyrone Blackburn has to meet, this requirement is on Tyrone Blackburn's shoulders to meet under 3211A. It's a higher standard than the usual motion to dismiss. Any case involving public participation must plead and prove the defendant published the statement at issue with actual malice by clear and convincing evidence. Moreover, the anti-SLAPP statute provides for a mandatory award of attorney's fees to a defendant where a plaintiff commenced or continued an action involving public participation without a substantial basis in fact and law. Then the argument. All right, so they're going to say each of the plaintiff's defamation claims are subject to the anti-SLAPP statute. So as the judge is going through this and weighing this motion to dismiss, they're saying, look, judge, you should look at every single claim with this heightened requirement, this actual malice standard, according to what you're supposed to follow when something deals with public participation. That we're arguing that it all involves a public participation standard. They say an action involving public petition and participation is a claim based upon 1. Any communication in a place open to the public or a public forum in connection with an issue of public interest, or 2. Any other lawful conduct in furtherance of the exercise of the constitutional right of free speech in connection with an issue of public interest, or in furtherance of the exercise of the constitutional right of petition. Public interest shall be construed broadly and shall mean any subject other than a purely private matter. Here, Tacopina's interview with TMZ regarding plaintiff's arrest is undoubtedly a matter of public interest, considering the interview discussed the arrest of plaintiff, who is an attorney and officer of the court. The nature of such position mandates not only conformance with the law, but adherence to a code of professional ethics and how those duties are discharged. And they cite here Hate v. Newsday. So I guess there's a case that deals specifically with when you're speaking about an attorney, because they're officers of the court, it becomes inherently like a matter of public interest. Certainly, an attorney who's arrested and charged with second-degree assault for injuring a process server in the performance of a process server's efforts to serve that attorney is a matter of public interest. In fact, plaintiff all but concedes in his complaint that Tacopina's interview with TMZ is conduct that falls within the anti-SLAPP statute with respect to his defamation claims. And then they cite the complaint. Accordingly, as defendants have met their initial burden in seeking dismissal, the burden shifts to plaintiff to establish, so remember plaintiff is Blackburn, to establish through clear and convincing evidence that its defamation claims have a substantial legal basis. Now, clear and convincing, that's higher than preponderance. It's less than reasonable doubt, but clear and convincing is substantially more likely than not to be true, right? So you've got to have a strong belief. The judge would have to have a strong belief that there is a substantial legal basis to not dismiss under this type of motion with the standard. If they agree that anti-SLAPP statute applies to each of the claims here. Next, we have each of plaintiff's defamation claims are subject to dismissal. Section A, we've got Tacopina's statements to TMZ were not defamatory because they were true statements or consisted of inactionable opinion. Looking at each of the alleged and falses in quotes here, alleged false and defamatory statements identified in plaintiff's defamation claims, it can be seen that each involve statements that are substantially true, and for that reason may not form the basis of a valid claim for defamation or otherwise consist of non-actionable statements of opinion. In order to assert a cause of action for defamation, plaintiffs must allege A, that a false statement that tends to expose a person to public contempt, hatred, ridicule, aversion, or disgrace. B, published without privilege or authorization to a third party. C, amounting to fault as judged by, at a minimum, a negligence standard. And D, either causing special harm or constituting defamation per se. So, because falsity is a critical element of a defamation claim, truth is an absolute defense. And in determining if a statement is true, exactitude is not required. The test is whether the statement is substantially true, right? So you don't need to prove beyond all doubt that something's true. Exactitude's not required. And then truth need not be established to an extreme literal degree. In determining whether a statement is substantially true, the courts are to look at whether the statement as published would have had a different effect on the mind of the reader from that which the pleaded truth would have produced. As such, a defamation claim will fail, even where a substantially true statement contains minor inaccuracies. So, for example, if maybe if the process server age is an issue, like if I don't know the process server's age, but if the guy wasn't 66 years old and Tacopina was saying, he ran over a 66-year-old man and the man's really like 65. Does that invalidate? No, that's just a minor inaccuracy. Further, since falsity is a necessary element of a defamation cause of action, and only facts are capable of being proven false, it follows that only statements alleging facts can properly be the subject of a defamation action. Thus, an expression of pure opinion is not actionable, no matter how vituperative, I like that, or unreasonable it may be. In distinguishing facts and opinion, the factors the court must consider are 1, whether the specific language has a precise meaning that is readily understood, 2, whether the statements are capable of being proven true or false, and 3, whether the context in which the statement appears signals to readers or listeners that the statement is likely to be opinion, not fact. All right, so that's all the case law that they're relying on here. And then moving to how it applies, they say in his complaint in this case, Blackburn identifies several statements that Tacopina made during the TMZ interview as defamatory, which the documentary evidence makes clear are in fact substantially true. For instance, plaintiff highlights Tacopina's response that TMZ could take allegedly out of that question. Because remember, TMZ was like, oh, he allegedly did this, and Tacopina said, you don't have to say the word allegedly. When Tacopina was asked about plaintiff allegedly driving over your process server, and that plaintiff took his car and ran into a 66-year-old man. However, the videos, and they're citing here too an affidavit from Peter B. So we'll take a look at that when we finish this section. However, the videos and photographs put forth reveal that plaintiff did in fact strike Hunt with his vehicle, while Hunt was seeking to serve him with the amended complaint, resulting in an injury to Hunt. And then they cite Hunt's affidavit, and if it looks like 4 total exhibits. Well, 3. So maybe the affidavit, the video, maybe the injury, the photo. And if you missed it, if you're tuning in late, we watched the video of the process server where I think it's pretty apparent he gets struck because his leg is like gouged open. You could check that out. It's right at the beginning of this video. While plaintiff also claims that Tacopina falsely asserted during his interview that plaintiff committed felony assault, a review of the recording of the interview makes clear this is simply not true. Tacopina stated during the TMZ interview that plaintiff was arrested. Oh yeah, that's a big difference. So the claim of Blackburn is Tacopina says he committed felony assault, And Tacopina's like, no, no, no. I said that he was arrested for committing felony assault on someone. Those are two different statements. This is indisputably a true statement. Stating that plaintiff was arrested for a crime is significantly different than stating that plaintiff actually committed a crime. That plaintiff was not ultimately indicted on second and third degree assault after being arrested does not render Tacopina's statement any less true. He was, in fact, arrested for felony assault. It only means that defendant wasn't indicted for his actions. In fact, the criminal court's decision dismissing the indictment stated there was sufficient evidence to indict plaintiff for each of the crimes alleged. And then they cite Peter B.'s affidavit, vacatur of his original indictment, and the failure of the prosecutor to re-indict him doesn't mean history is rewritten and his arrest evaporates. it just goes away. It's just an intermittent mist. It just goes away. As to each of the other communications by Tacopina from the TMZ interview, that the plaintiff's claims are defamatory, the plaintiff used the court system to shield his extortionate tactics, that plaintiff is an embarrassment to the legal community, and that plaintiff's arrest was the latest example of his malicious and manipulative pattern of conduct, each clearly amount to non-actionable opinion. Footnote here. Look at the footnote. Oh my gosh. Look at this. He says the statements are also substantially true. See, and then we have a reference to an affidavit citing to the decisions in Jones v. Combs, Jakes v. Youngblood, Dixon v. Cartagena, and Cartagena v. Dixon. Because remember, there's like different sanctions. There's multiple sanctions decisions in the different Cartagena-Dixon cases. So we have a multiple cite to those cases because there's just been so many issues within those cases. Oh my gosh. And then we have an explanation after all these cites. For example, the judge in Jones v. Combs noted, Blackburn's filings are replete with inaccurate statements of law, conclusory accusations, and inappropriate ad hominem attacks on opposing counsel. Both the operative complaint and Blackburn's opposition brief are full of similar irrelevant insults, misstatements, and exaggerations. So that's the footnote. Oh my goodness. And I would say this is pretty pared down because there's like other cases, like the Otkin case, the Otkin decision, I don't think is referenced here. Because the Otkin decision was that like Nicki Minaj case, I think. So I don't see that one listed wherever he was judge, I don't think. Man, what a footnote. Equally as non-actionable opinion is a statement, he didn't vet these claims at all before filing this lawsuit. They cite back to Peter B.'s affidavit. To be clear, Tacopina did not say this. This was a question that was asked of Tacopina. Wow. Okay, so the complaint that we just read before this, what is the quote? So the filing, Tyrone Blackburn's attributing that quote. Okay, so let's see. All right, so when I search for the word vet, this is over in Tyrone Blackburn's complaint. It gives a timestamp and says, he didn't vet these claims at all before filing this lawsuit. That's what's in quotes. It says, this statement falsely asserted as an established fact that plaintiff, a licensed attorney, filed a lawsuit without conducting any pre-filing investigation, factual inquiry, or professional diligence into his client's claims. And remember, there's actually Rule 11, and remember, Rule 11 deals with like failing to properly investigate before filing claims and doing this factual inquiry. It seems like Rule 11 sanctions are forthcoming, that Judge Jennifer Willis in the Dixon and Cartagena cases said they're forthcoming, but hasn't published her opinion yet, which I'm assuming it's going to be lengthy. So when that finding comes down, if I take it at her representation that it is forthcoming, if and when that comes down and sanctions are awarded after Roc Nation filed their Rule 11 motion for sanctions against Tyrone Blackburn for his failure to do a pre-filing investigation. Then you're gonna have a judge who specifically made this finding. So, like, just wait like a week or two from now. My goodness. So anyway, this is Blackburn saying that this was the quote, and that Tacopina made this objectively verifiable statement of professional conduct, not rhetorical opinion, and it purports to describe what plaintiff did or did not do as an attorney in the actual exercise of his legal duties, and the statement is false. So back over to what we're reading here from this motion to dismiss. Tacopina did not say this. This was a question that was asked of Tacopina during the TMZ interview. In any event, while Tacopina agreed with this assessment, both the question and Tacopina's response are clearly statements of opinion. A review of the dictionary.com. Is this a back-to-back stream? The last time we got together for a Tyrone Blackburn stream, we had Judge Jennifer Willis citing Merriam-Webster to define quotation for Tyrone Blackburn in her order, her decision. And now we're reading this motion to dismiss, and now we're getting dictionary.com cited to define vet. So, the definition of vet evidences that it means the act or process of appraising or checking a person or thing for suitability, accuracy, or validity, and then they link to the dictionary definition for vetting. In agreeing with this assessment of the quality of the review of the allegations made against Cartagena in Dixon's lawsuit, all Tacopina was doing was expressing his opinion that the allegations therein had not been checked for accuracy, given his stated belief that they were false. And when Dixon filed his most recently amended complaint, after he missed the deadline to respond to motions to dismiss, some of the claims were just pruned out entirely. And the parties came in and they're like, look, that suggests that they were frivolous claims to start. And Tyrone Blackburn responded, well, that's not true. It was just strategic pruning. It was just strategy to prune it down. It's just meant for efficiency. But I think there's a strong argument that if you're claiming some civil RICO went on between all these different defendants that Terrance Dixon brought this lawsuit against, and then you prune out the RICO and all of that, maybe it wasn't a properly vetted claim from the start, and by taking it out, you're hoping to avoid the initial request for Rule 11 sanctions brought by Roc Nation. So, I don't know. There's a lot to play out in that case still. Cases. So my goodness. In each case, the comment consists of a statement that is not capable of being proven true or false, expresses a personal perception held by Tacopina, and is issued in the context of an interview in which such personally held beliefs would be expected to be the subject of the discussion. TMZ is known for being a gossip website, not 60 Minutes. Viewers would naturally expect that what was being offered was opinion, not a summary of the results of some kind of investigatory expose on plaintiff. That's hilarious. I mean, and I think TMZ would wear this as a badge of honor rather than shade. All right, so we finished this section. Let's get over to the Peter B. affidavit that's been cited. Let's do that. Let's go find it. Yeah, where is it? Oh, here. It's right at the top. All right, so this one's kind of long. We're going to still call him Peter B, because I don't want to keep messing up his name. Hey, Derek. Hey, good to see you. Hey, Kristen. Let's see. Can you cite your own cases? I mean, but the thing is, he's not citing, it's not like you're citing an argument that's being made, or like saying like, hey, this was said in a pleading, so you should accept it as fact. It's citing an order, right? I think those cites were 2 orders from one of the Judge Jennifers, probably Judge Willis, for the most recent one, and then likely the Judge Jennifer Rochon ruling on the sanctions relating to the misdepositions, right? So you're citing to a judge's order. It's a little bit different than just like citing your own words in a pleading. Hey, AV. AV says that footnote is beyond accurate. It was nice and long, had clickable links. And guys, I explained earlier, sometimes we click all the links that we see and really dive into it. I've been losing my voice, so we're gonna like avoid some of the side quests on going and looking at those cases, especially we're obviously following Dixon and the Cartagena cases, but we've seen those other cases, the judge's orders and their quotes referenced multiple times. Like I'm almost like they're becoming cliches or motifs at this point. But they're linked in this. The link to the docket is in the description, so go check out that link and you could find everything here. And you can go click all of those links that are in that glorious footnote. Love a good footnote. I don't remember what tab I had open. This one? There we go. Good to see you, AV. AV, you guys, a lot of people are asking about what's going on with Keefe D and all of that mess. And AV is the person I always recommend for coverage on that case. And I believe that's still, unless it's gotten delayed, that's supposed to be coming up the next week or two, right? That trial finally. So follow AV anyway, but especially if you have an interest in that case, that trial. And then also recently, since we're speaking of like Rock Nation, this Rule 11 motion for sanctions, Alex Spiro did a lot of like the heavy lifting. His team, his co-counsel, has done great work as well in putting together and tracking all of the issues for the Rule 11 motions in relation to Tyrone Blackburn and the Fat Joe cases. But also, if you're just interested in Alex Spiro doing some filings, I think go check out AV's most recent stream where she discussed, I think, Tupac's brother or some member of the family. Spiro's representing them. So if you like good attorney sparring, there's some more for you that I think you'll be interested in. So good to see you, AV. So good to see you. And also, thank you for gifting the 5 gifted here. Super, super nice. If you got a gift, make sure you say thank you. We're joking of the day here that the gifts are hitting a process server. So AV just hit 5 members of the chat with love. Big thank you here. And guys, we got the affirmation in support of motion to dismiss. Okay, I've been calling it affidavits. I guess it's a different thing. I guess it acts the same way. Is it substantively different, an affirmation versus an affidavit? Maybe I should check that out before we just read this blindly. Or is it just a New York thing? Okay. Okay, so a quick search says that an affirmation in New York State is an unsworn written statement that replaces a notarized affidavit under this specific statute. All right, so that's why we're calling it an affirmation of truth statement. An affirmation of truth, the statement of any person wherever made, subscribed and affirmed by that person to be true under the penalties of perjury. All right, so it is being sworn off on. But other than in a deposition or an oath of office or an oath required to be taken before a specified person other than a notary may be used in an action in New York in lieu of and with the same force and effect as an affidavit, certificate, a response to a notice to admit, an answer to interrogatories, a verification of a pleading, a bill of particulars, and any other sworn statement. Such affirmation shall be substantially the following form, and then they give like template canned copy. All right, so an affirmation affidavit, it's taken with the same force and effect. So good to know. Good to know. So Peter B., in accordance under the penalties of perjury under the laws of New York, which may include a fine or imprisonment, affirms that the foregoing is true, except as to matters alleged on information and belief, as to which matters I believe the foregoing to be true, with an understanding that this document may be filed in an action or proceeding in a court of law. When was this prepared? It was filed 7/27. 27th day of July, signed off yesterday. All right, so I'm an attorney duly licensed to practice law in the state of New York, and I partner with Goldberg Segala counsel for defendant Joseph Tacopina, and Tacopina Siegel trial lawyers who are doing business as Tacopina, Siegel, and Diorio in the above entitled action, and as such am fully familiar with the facts and circumstances underlying the instant motion. I submit this affirmation, along with attached exhibits and the accompanying memorandum of law, for an order. We're going to skip all this, but it's the motion to dismiss with prejudice and grant attorney's fees. In support of the instant motion, annexed hereto and made part are the following exhibits. So we've seen that exhibit list, guys. And again, link in the description if you want to go check them out. We are going to go through them as they're mentioned where relevant. First off, plaintiffs and Dixon's coercive efforts to shake down Cartagena through a series of false claims. So Blackburn and Dixon, at various times between 2006 and 2019, Dixon was employed with Cartagena as a hypeman, in which capacity he would assist Cartagena during tours and concerts, and was, quote, handsomely compensated, a standard industry rate. And they put Exhibit B, and that is, they're citing to the complaint. They're citing to the complaint. However, starting in 2003, 4 years after the business relationship between Cartagena and Dixon ended, Dixon began an online public campaign against Cartagena by making several false and defamatory statements through his public social media accounts and threats to Cartagena's manager, accusing Cartagena of sexual assault and statutory rape. Now, isn't that the irony of this, right? We're gathered here today to talk about Tacopina's motion to dismiss Tyrone Blackburn's recently filed defamation lawsuit against Tacopina, and like the 2 others he filed against a dozen other parties. But this whole time, there's still, I think if we go pull it up right now, on Tyrone Blackburn's Instagram account, but during his deposition, he's like, well, that looks like my name. That looks like a picture of Tacopina. You've still got some of this commentary up. So here's like an email correspondence, and we've gone through these before, but it's from May 1st, 2025, Tyrone Blackburn, or the account Tyrone_Blackburn, tagging Joe Tacopina's account. I've been emailing you for several days trying to get an answer for my invitation to meet with Homeland Security and federal prosecutors so you can present your claim for extortion against my client and me, and I can present my claim for RICO and sex trafficking against your client, Fat Joe. Assuming you missed my last 3 emails, I figured I'd try to reach you here. It's mind-boggling that you're willing to tell TMZ, who's tagged, that my client and I are attempting to extort Fat Joe, but you're not willing to accept my invitation to meet with federal prosecutors and investigators. One would think that if your client is being extorted, you would seize the opportunity to present the extortion attempt to law enforcement. So again, Tyrone Blackburn's just been out here willy-nilly extending invitations for people to go meet with Homeland Security. Like, I'm not aware of that being the way things work. But yeah, and then there's like a post. Where's Taka? Yeah, got this still up here. You ran and filed a baseless lawsuit against. So this is an accusation of frivolous filing, right? Which Tyrone Blackburn in his complaint is saying such an allegation, such a claim, such a public statement would be defamation per se. That's his argument in his complaint about the statements that Tacopina has made to TMZ. Does Tyrone Blackburn, can he make a footnote linking to 4 different orders from judges in different cases saying, hey, we find that he like runs and files things to garner media attention? Does Tyrone Blackburn have that to lean on, or is he just saying this without any basis of truth? But he's suing Tacopina for allegedly doing this, making these types of defamatory statements against him. So he says that you're alleging defamation and intentional infliction of emotional distress in an attempt to get ahead of the forthcoming lawsuit against your client, Fat Joe. No matter how hard you try to deflect and cherry pick emails and conversations, your client has a lot of explaining to do. I invited you and me to meet with the Southern District of New York prosecutors, but you've yet to respond. You can bring your baseless accusations of extortion, and I will bring the 19-minute audio recording of your client's felonious henchman, Pistol Pete, soliciting a former member of Terror Squad to lure my client to a specific location for Pistol Pete and his thugs to pound him out. Now, I believe that there's been continued discovery requests through the end of the discovery deadline in the Cartagena case. Still where it was referenced that the defense was never provided this. I believe this is one of the pieces that they say that they were still not provided with. Your client, Fat Joe, ordered a hit job against my client. This isn't like I've heard. This isn't like this person told me, or I read this article that said this is a claim that your client ordered a hit job against my client. And he's saying this when there's been no litigation filed yet by Dixon alleging such. Pistol Pete also discusses how he had to run down on Tony Yayo, a member of G Unit Brands, due to some feud with 50 Cent, and run up into clubs that attack other victims. Your client should also prepare to answer questions surrounding 2 additional recordings where 2 females discuss your client's disgusting pattern of grooming and sleeping with 16-year-old children. So these are the statements that contributed to Tyrone Blackburn being named as a defendant in like these types of accusations, where he became named a defendant himself in this action that Fat Joe brought against Terrance Dixon and Blackburn. This type of sentiment coming from Blackburn that your client is doing these things. Peter B. All right, so there was some context there to what Peter B's talking about here. Dixon subsequently began making additional false claims in March 2025 that he was not compensated or given credit for songs that he wrote for Cartagena. At some point after making these claims, Dixon retained Tyrone Blackburn, who has a history of being chastised by several judges in federal court, including the Honorable Denise Cote of the Southern District of New York, who referred plaintiff to the grievance committee based on findings that a reasonable inference can be drawn that plaintiff, quote, filed cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressure defendants to settle quickly, in apparent hopes of securing a settlement payment from Cartagena. Oh, this is a long footnote. let me get a drink. Guys, look at this footnote. This 2 footnotes here. Oh my god. This is the whole page. There's 2 lines of not footnote. Oh man. My goodness. Let's get this embiggened. Oh my goodness. True to form. This is the first footnote. Plaintiff has been sanctioned in the Cartagena action based on his disturbing behavior during his deposition, including referring to attorney Chad Siegel of the TSD firm as a piece of shit, asking, "What date is your transition surgery?" and stating, "Your mother is an alleged criminal. She should have spit you out instead of swallowing," resulting in the court issuing an order, which, in the forceful language that follows, referred Tyrone Blackburn to the grievance committee of this district based on his behavior at the February 24th and March 6th depositions and the subsequent cross motion for sanctions. Blackburn's ad hominem attacks on opposition counsel at the February 24th deposition were outrageously unprofessional and unacceptable. Blackburn's repeated use of improper objections and interjections at the deposition were a clear violation of Rule 30c2. Blackburn's decision to proceed with the March 6th deposition, while allegedly so impaired by narcotics that he was unable to confirm whether he represented Dixon, demonstrated poor judgment and disregard for the judicial process. And I say Blackburn's cross motion for sanctions is replete with inaccuracies and serious unfounded accusations against opposing counsel. And myself. I wasn't directly named, but a YouTube channel that was purportedly getting like handoff direct information from Fat Joe's legal team and publishing this confidential material. I got it from the docket, and that was a gripe in Blackburn's cross motion for sanctions, claiming that Tacopina was coordinating with Complex Magazine and a YouTuber to disseminate stuff that was confidential and not publicly accessible, that Tyrone Blackburn couldn't even access himself, according to him. They go on to say the meritless motion, and I believe Judge Jennifer Willis called those accusations meritless in her order, is based on conjecture by Blackburn, which was evident by his inability to defend his assertions, both in his reply briefing and at the oral argument. And there's like a window when transcripts aren't available through Pacer, but after several months they become available. So that should be coming up soon. I think the arguments were May 18th. So next month, a couple weeks from now, would be 90 days. So maybe we could get that transcript from the oral arguments, because this is the second time we've seen his conduct at these May 18th oral arguments brought up. That'd be interesting. His frivolous filing not only wasted this court's time, but wasted the time and resources of opposing counsel as well. The repeated admonishment by the court, both in this case and other cases, have been insufficient thus far to deter Blackburn's behavior. All right, and that's in quotes there. And they cite the order for. Okay, wait. Where did this quote start? Am I missing it? Oh, no, they're going to have to define a quotation to him. Anyway, they cite the order. It was a Judge Jennifer Willis order in the Cartagena action, and then the second footnote. Oh my gosh, it's long. Judge Coates' order goes on to further state. So this is a different judge, different case. Judge Coates' order goes on to further state that plaintiff's submissions to this court have been rife with disturbing allegations against the defendants and defense counsel. Blackburn has called defense counsel in this action a disgusting racist for rejecting his preferred mediators. In response to this court's order requiring plaintiff to submit an affidavit regarding the representation made by the plaintiff to counsel regarding Fisher's residence, Blackburn filed a wholly inappropriate 53-page affidavit containing multiple irrelevant and scandalous accusations against Fisher. Regardless of Blackburn's intentions, his actions in this and prior cases indicate a repeated failure to meet his Rule 11 obligations. So he's already been chastised for... So then it's not an opinion, it's not just a baseless statement to say like he's done this before, filing frivolous things without doing the fact-finding. I mean, that's what Rule 11 deals with. Those are his obligations, and here we're getting this quote from Judge Coates saying, and I imagine Tacopina is intimately familiar with this order and what was found. You have a judge making the finding. That, to me, is substantially true. Significant resources have been spent by judges of the court and defendants named in actions he's filed to address glaring deficiencies in his filings. Our referral to this court's grievance committee is warranted. So that's from Judge Coates' order. Then the footnote goes on. Oh my God, does the footnote go on to the next page? Oh gosh. Further eye-opening admonitions have followed plaintiff in connection with actions he's commenced in federal court, including Jones v. Combs, where the Honorable Paul Otkin, okay, so Otkin is the Jones case, the Jones v. Combs, issued an opinion and order stating that Blackburn's filings are replete with inaccurate statements of law, conclusory accusations, and inappropriate ad hominem attacks on opposing counsel. Both the operative complaint and Blackburn's opposition brief are full of similar irrelevant insults, misstatements, and exaggerations. Jakes v. Youngblood, where the Honorable William Stickman issued a memorandum order stating that, quote, the fact that Blackburn submitted fabricated quotations and misleading analysis of case law is plain to see from the face of the briefs. When reviewing Blackburn's briefs, the court was perplexed. Oh my gosh, look how long it is on the next page. File an exhibit of just your footnote. This would be like if this is double spaced, this would be like a 4-page footnote. Oh, okay, wait. So when reviewing Blackburn's briefs, the court was perplexed to see quotes attributed to the court's own prior opinion in this case, as well as other case law that was wholly fabricated. The court was also troubled to find that Blackburn repeatedly misrepresented case law to support his contentions. Even after being accused of making false representations in his initial brief, Blackburn's reply brazenly contained misinterpretations of law and partially fabricated quotations. Whoever or whatever drafted this brief, the brief signed and filed by Blackburn, it is clear that he, at the very best, acted with culpable neglect of his professional obligations. The alternative is that he acted in a conscious effort to deceive and mislead the court. At this point, in light of Blackburn's continuing offenses in his reply brief, the court is inclined to believe the latter. Next up, they bring in Dixon v. Cartagena, where the Honorable Judge Jennifer Willis stated in an order. This is the July 10th, 2026 order that we read on our last stream. Stated in an order that Blackburn's repeated inclusion of fabricated quotes in his filings. This is where we define quotations. Oh my goodness, what a time that order was. demonstrates a pattern of complete disregard for his ethical obligations to make accurate representations to the court. He's been sanctioned repeatedly for his reliance on AI without verifying the quotations and citations before filing his submissions. Worse still, while he represented to a court last year that he understands words must never be enclosed in quotation marks unless they accurately reflect the precise language of the cited source, he brazenly minimizes and attempts to justify identical behavior here. When his fabricated quotes were discovered by counsel for Roc Nation in this case, he doubled down and made baseless accusations against opposing counsel. For those reasons and all the reasons stated above, the motion to strike is granted and the motion for sanctions will be considered unopposed. A separate order. So this is what I said earlier in this stream that, she represented that a order is going to follow. I just haven't seen it yet. A separate order on the sanctions will follow. Additionally, this court made a referral of Blackburn to the Southern District of New York's Grievance Committee in its last order on sanctions. Blackburn's citations to fabricated quotations and complete lack of acceptance of responsibility after previously being sanctioned for the same exact behavior is an outrageous breach of his ethical and professional obligations. Accordingly, this behavior will be incorporated in his referral to the Grievance Committee. And actually, I think this is a good housekeeping moment. If you don't see community posts, or if you're not on X and don't see my X posts, I believe last stream, I may have said like, oh, there's an order to show cause and there's going to be a hearing taking place in front of Judge Jennifer Rochon, the other Jennifer. And if you missed those posted updates, let me look at it, the Cartagena docket, because the order is published on the docket. That didn't take place. It was like reassigned to Judge Jennifer Willis, and then Judge Jennifer Willis canceled this hearing for the time being, adjourned it in relation to the motion to withdraw. Because remember, Tyrone Blackburn's also trying to withdraw his counsel for Terrance Dixon. There's a lot going on. So if you remember from a previous stream and you're like, hey, what happened with that? Just know that that hearing was adjourned. It just didn't happen. All right, is that the end? I think that's the end of the footnote. Let's double check. Okay, we made it through that footnote. We made it through that monster of a footnote. Now we gotta go back up. All right, so it ended here. All right, so back to this affirmation. Back to the affirmation. In fact, further to this effort, plaintiff wrote a demand letter on March 23rd, 2025, on behalf of Dixon, demanding compensation as, they're going to call us the first demand letter, a ghostwriter and uncredited vocalist for certain songs from Cartagena based on various legal theories, and threatened to commence litigation if he received no response. They say, see Exhibit B to the affirmation of Tacopina, dated July blank. They didn't fill this in. So we didn't fill this in. Unless Tacopina didn't sign it yet, but we're referring to it. So we'll look at we're going to read Tacopina's affirmation as well. So just know that that's coming. A second letter followed from plaintiff dated April 21st, 2025, the second demand letter, which not only sought compensation, but made new outrageous claims, including violations of the Trafficking Victims Protection Act, TVPA, for alleged acts of forced labor and coercive sex trafficking. Now remember, Dixon is the person, like the party on behalf of whom Blackburn is sending these demand letters. So to claim that we're gonna like bring a case against you under TVPA, you would think that the claim is going to be it's the party sending this demand letter who would have standing to bring such a claim. And then in the complaint that Dixon ends up filing, even though he says like, look, you're Fat Joe, I engage in some of these sex acts, and like they were like recording it, they were present or whatever. That complaint also raised issues that didn't have to do with Dixon. And it was weird because it's like, what is your standing to include this in your complaint, your causes of action against somebody else when you aren't a part of it? It was just a weird writing. And it seemed like at some point the complaint started hallucinating, because it almost started to, it was like this weird paragraph just like defending Desiree Perez, the CEO of Roc Nation, and Roc Nation was a defendant in the lawsuit. It was just a very bizarre complaint that was filed. But here, Peter B's characterizing like, hey, in these demand letters before Fat Joe brought his case, these new outrageous claims come in. So first you're like, all right, we want more money for this old work. Then, when we don't get that money, we're sending another demand letter and we're going to say, not only do we want this compensation, but we're also going to bring a cause of action against you under TVPA, which is, a very, very, there's a stigma to being accused of such a thing. You're a celebrity, so if we accuse you of such a thing, probably going to make the headlines. And they say for alleged acts of forced labor and coercive sex trafficking, and included a draft complaint which plaintiff threatened to file if the demands were not acceded to within 4 days, which was followed by threats made to Cartagena's personal counsel, Erica Moriera, to report Cartagena to Homeland Security. A third letter followed on April 25th, 2025. And now this one I don't think I've seen. We're going to look at this. We're going to look at all the letters when we go through Tacopina's affidavit. But I saw this filed when having a conversation with ... /star. And I thought it was so interesting because when we looked at the deposition transcripts, Tyrone Blackburn tried to say that this correspondence, these letters, were not demands. They weren't demands. They were just requests to like start a friendly conversation, I think was his wording in the deposition. And I'd never seen this specific letter, although I think we've seen others either referenced or included as exhibits before, like the other 2 demand letters. And the chat consensus was like, no, I mean, these letters aren't friendly conversation requests. They're like requests for money, demands to settle before we actually file something. I just want to pull up this one letter and show you the header of it. What exhibit? Exhibit E. That's not, okay, it's exhibit E to the affirmation. There's so many exhibit E's. Look at the header on this letter. Look at the header on this letter. I read this, I couldn't wait to have the chat here with me. It says, for settlement purposes only, not to be used for any other purpose. Like starting a friendly conversation. So we have this deposition testimony from an attorney, Tyrone Blackburn. Not a layperson who might not understand, like litigation letters, pre-litigation communications, things like that. An attorney who engages in this area of law, has filed many cases with claims similar to what he's claiming Fat Joe partook in. And during his deposition, he's just like, demand letters, what are you talking about? Those weren't communications for the purpose of seeking like an economic settlement, hush money, extorting something out of you. It was just to start a friendly conversation. And then the header of this letter says, no, it's for settlement purposes only. Just crazy. Just crazy. So, oh my goodness. My goodness. Anyway, I side storied there. And we're going to read that in full. We're going to read that in full when we get to it in order. It's just so much. Like, there's just so many layers. Like, this is just perpetually a hot mess. All right. So then the letter was filed, that April 25th letter, now demanding a settlement of $20 million, containing more false claims and the threat that litigation would commence immediately if not responded to that same day. The letter was followed by 4 daily after-hour emails containing further threats, and these were referenced in the initial complaint by Fat Joe. And another call between plaintiff and Cartagena's counsel where plaintiff threatened to bring RICO claims. Next up, we've got commencement of the Cartagena action in service of the amended complaint upon Blackburn. As the public campaign by Dixon against Cartagena and the continuous threats from plaintiff were showing no signs of relenting, Cartagena directed defendants to proceed with commencing a lawsuit in an effort to obtain judicial relief from the threat and intimidation campaign that was being waged against him. Further to this direction, the TSD firm commenced the Cartagena action on April 30th, 2025. The complaint, which was amended on May 1st, 2025, joined Dixon, plaintiff, and plaintiff's law firm Blackburn Law PLLC as defendants, and alleged causes of action for defamation against Dixon and intentional infliction of emotional distress as against all defendants. As a courtesy and in an effort to avoid issues related to service of process, Tacopina wrote to plaintiff on April 29th, 2025, and advised him that he would be named a defendant in the Cartagena action. In response, Blackburn said he would waive services for any BS lawsuit your pedophile client wants to file against me, but conditioned that waiver on Tacopina meeting Blackburn at the Southern District New York Prosecutor's Office to file your extortion claim. Now, is this context that Tyrone Blackburn included when he said, oh, the only reason you would have sent a process server out to meet me would be to intimidate me because I'd waived service. So there's no reason you would have done that. Now we get more context. Is this context significant? If his waiver of service is conditioned on Tacopina meeting Blackburn at the prosecutor's office, I'd actually argue that this is intimidating, that this response is intimidation. That's just me. Given that the offer to waive service was conditioned on involving prosecuting authorities to, in effect, review defendant's extortion claims against plaintiff and plaintiff's baseless TVPA violations, Reed Smith LLP, there's a footnote here, proceeded to retain court support, process service company, to effectuate service upon plaintiff. All right, let's read this footnote about Reed. Reed Smith is of counsel for the TSD firm in the Cartagena action. All right. Court support selected Vincent Mineta from its network of process service to effectuate service upon Blackburn, with attempts being made on May 5th, May 6th, and May 7th to personally serve Blackburn to no avail, causing Mr. Mineta to affix a copy of the summons and amend a complaint to Blackburn's residence at 1242 East 80th Street, 3rd floor in Brooklyn, and mail a copy of the same to Blackburn's residence. Now, all right, the process server confirmed Blackburn's residence through his DMV abstract. Now, I believe in Tyrone Blackburn's testimony transcripts from the grand jury proceedings, I think he stated that that's also where his law firm's addressed to. So he's a solo practitioner, TA Blackburn Law, PLLC, and he said that it's like the same address. So his residence and place of business, same thing. On May 8th, 2025, Blackburn sent email correspondence to defendants and Reed Smith, which reaffirmed that his offer to waive service was conditioned on involving prosecuting authorities, namely Homeland Security. So wait, May 8th versus April 29th through May 8th. So more than a week later, Blackburn's still saying, after the attempts to affix something to the door, right? Multiple attempts. Blackburn again sends, hey, there's a conditional waiver here. Homeland Security and assistant U.S. attorneys from the Southern District of New York, along with claiming that his domicile is not in New York, despite the DMV abstract disclosing that New York was his domicile. Was this stuff presented to, man, this is crazy. Because the this is just crazy. How do you read this and not walk away with a reasonable conclusion? I just don't see how you can even argue it's unreasonable to conclude that you're playing games with process service. Oh, I'll waive service if you do this. And then you start claiming that you're not domiciled here. Just stating like you're not going to be able to effectively serve me at that address. I'm not going to get whatever you fix to my door. I'm not domiciled there. It's not the place to serve me. How can you then claim, hey, they should have known that they didn't need to send a process server because I waived service. I was willing to be served. I wasn't trying to avoid service. I was afraid that somebody followed me home from the Diddy trial. I didn't know they were process servers trying to serve me. I thought they were trying to cause me harm. I was scared. And that's why I pulled out of my driveway. When you're playing games like this, before that incident actually happens, this to me is a good faith basis to draw the conclusion that when Tyrone Blackburn is seen on videos pulling out of that driveway and then the process server has like a gash on his leg, Tyrone Blackburn looks like he was trying to avoid being served. In light of this response, Reed Smith proceeded to contract with Guidepost Solutions, who selected Mr. Hunt to have Blackburn personally serve with the amended complaint. So this decision to send Mr. Hunt specifically wasn't at the call of the defendant in this defamation case being brought by Tyrone Blackburn. Tyrone Blackburn's representing that they chose this particular process server for a nefarious purpose, intentionally. And the personal service on Blackburn was necessitated by his representation that New York was not his domicile. According to the affidavit of service sworn to on May 16th, 2025, filed in the Cartagena action, Hunt attested that he observed plaintiff in the driver's side of a vehicle in the driveway outside of the address and approached the driver's side of the vehicle and stated, "Tyrone, you're served." Plaintiff did not lower the window, causing Hunt to place the amended complaint underneath the windshield wiper. Hunt also attested in a separate affidavit that in response to Hunt's efforts to serve Blackburn, that Blackburn abruptly placed the vehicle in reverse and in doing so struck Hunt's leg with his vehicle, causing a gash on his leg. And that's going to be the photo. If you want to go look at that, you can. We kind of saw it in the video. So I think it'd just be gratuitous to pull it up as a photo on screen. Hunt attested in this affidavit that he believed the plaintiff reversed the vehicle in an effort to avoid being served. All right, so he's attesting in an affidavit that he believed this was to avoid service. So if somebody else is saying avoiding service, they're relying on somebody else attesting to it. Hunt's version of events are corroborated by 2 videos that were taken during this incident and a photograph taken of Hunt's leg immediately after the incident. Next up in the timeline. So we're like this is like the May stuff. That's all like a year ago already. Plaintiff's commencement of the Dixon actions. Now we're in June. As Cartagena refused to succumb to Dixon and plaintiff's extortionist settlement demands, not friendly conversation requests, plaintiff followed through on his threat and commenced his own action, the Dixon action, on June 19th, 2025. In my opinion, I've said it before, this got way more media coverage than Fat Joe's filing against Dixon and Blackburn. And that could be for multiple reasons, right? It probably gets more clicks when the celebrity is the one being accused of very salacious things, as opposed to, hey, we're suing some hype man that less people presumably know than the name Fat Joe, and an attorney. Like, there might be interest in that type of story. I think it's interesting. Why is an attorney being sued? I'm going to read that. But a lot of people, there was coverage of this, and I got the impression that people did not even know that there was already a lawsuit filed by Fat Joe, right? This was a much bigger story. The Dixon complaint joined Cartagena and several other defendants and made baseless RICO, sex trafficking, and forced labor claims. In addition to the prior false and salacious allegations that had been made in the course of the previous efforts to extort monies from Cartagena, the Dixon complaint contained several allegations of Cartagena engaging in sexual acts with underage girls, despite none of the causes of action from the Dixon complaint having anything to do with those allegations. It was a weird complaint. I think poor Happily Angry Lawyer did a full reading of the complaint. Poor thing. So it was a long complaint, and it just seemed disjointed and piecemealed in ways that weren't relevant. It was just an odd read. The Dixon action has since been consolidated with the Cartagena action, and motions to dismiss have been made on behalf of all the defendants in the Dixon action. Plaintiff's arrest and the TMZ interview with Tacopina. On June 25th, 2025, Blackburn was placed into police custody, arrested and charged with violations of Penal Law 120.0514, which is a second-degree assault and a Class D felony, and Penal Law 120.20 and 120.00 subsection 2, which are reckless endangerment in the second degree and third-degree assault, respectively. Tacopina was contacted by TMZ. So, according to Peter B., this affirmation, Tacopina was contacted by TMZ. It's not Tacopina taking the initiative to provide information and seek somebody out to orchestrate some grandiose complaint scheme. So they say later that day, I was asked to give his reaction to Blackburn's arrest. So we're going to read Tacopina's version in his affirmation. Tacopina, who previously reviewed Hunt's affidavit of service upon plaintiff, a separate affidavit from Hunt where he stated that he believed plaintiff struck him with his vehicle to avoid being served, 2 videos disclosing Hunt's efforts to serve plaintiff showing he was struck by plaintiff, and a photograph of Hunt's leg after it was struck by plaintiff's vehicle, showing a significant gash on his left leg, proceeded to give several statements that he believed, and still does believe, to be true. And we got a footnote here, right? So we're laying out all of the things. Blackburn says certain statements are defamatory. We're laying out all of the things that formed the basis for Tacopina's statements. So the footnote here says the full TMZ video with Tacopina can be accessed here. In response to TMZ asking about plaintiff allegedly driving over your process server, Tacopina responded that you could take the allegedly out of that question and explain that Hunt, quote, was hired just to do a job of ... serving a lawsuit. Believed that plaintiff didn't want to be served, and that plaintiff took his car and ran into him. Tacopina went on to explain that an arrest warrant was issued for plaintiff, who was arrested this morning, and offered his opinion that plaintiff's arrest was no surprise, that plaintiff's arrest was the latest example of his malicious and manipulative pattern of misconduct, and that plaintiff was an embarrassment to the legal community. And I mean, I don't see how this is actionable. An embarrassment to the legal community. That just seems like an opinion that's not actionable. To call someone an embarrassment to blank professional community? Like, should we be allowed to punish people for saying you're an embarrassment to whatever fill in the blank? That's just an opinion. Tacopina further offered his opinion that it was a disgrace that it was a disgrace watching plaintiff use the court system to shield his extortionate tactics. All right? And to me, do we need to go back to the complaint? How did the cause of action claim extortion? All right, so this is this quote here. If we go over to where in Blackburn's complaint about this particular set of statements to TMZ, this is the complaint from Blackburn. Tacopina stated he really is an embarrassment to the legal community, this guy. It's a disgrace watching him use the court system to shield his extortion tactics. This statement falsely accused plaintiff of extortion and falsely asserted that plaintiff's use of the court system was a vehicle for criminal conduct rather than legitimate legal advocacy. I don't know. I feel like if you're using something as a descriptor, you've got a gray area there anyway as it being opinion. But even if it's a claim, if you can lean on Judge Coates' opinion, her order, where she says you do this and create these salacious allegations to garner media attention, I mean, kind of gives you a good faith basis to make a statement of such a claim rather than just it being a descriptive opinion. So either way, like, and I guess it's unusual. I do think it's unusual. My skepticism meter would be off the charts if like someone was walking around calling like an everyday attorney an extortionist. But here I think the context is critically important. Let's see. Back to Peter's Peter B. Okay. So here they say they further offered his opinion. So here it's an opinion. They're saying that he used the court system to shield his extortionate tactics. Did we get the quote wrong? That's actually why I wanted to look over, and then I didn't double check that because I went on my own side story. Did we incorrectly quote something? Oh, we did. Extortion tactics versus extortionate. To me, extortionate is very clearly a descriptor term, whereas extortion tactics, it could be a phrase like a joint phrase, where extortion tactics is the phrase, inseparable. Extortionate tactics is a descriptor. It's not a claim that somebody is engaging in criminal extortion. It's that your tactics have a certain characteristic about them. And we quote it wrong. We quote it wrong. We quote it wrong. Do we need to pull out the definition for quotations again? So again, very, very critical, I think, the difference here between what's in the quotes. So Tacopina, they say, provided context by explaining that plaintiff went from making a demand related to a claim founded upon Dixon not getting credit for writing songs, which demand was ignored, to a second demand claiming Cartagena had sex with minors. So he's explaining his belief, like while he's giving the statement to TMZ, he's not just going on TMZ and stating Tyrone Blackburn has engaged in extortion. He's committed this crime of extortion. He's saying he uses the court to shield his extortionate tactics. He relies on the court to say it's good faith litigation. It gives him certain protections, whatever. And goes on to explain why he thinks that. And he says, look, we went from, at first, you don't mention any of this stuff. But when we fail to give you the money that you're asking for, all of a sudden you circle back around in a matter of days and you pile on these outrageous claims of sex with minors. Could I would come to that conclusion that you're trying to blackmail me with something that doesn't necessarily exist. Tacopina concluded the interview by offering his further opinion that it should be shocking when a lawyer gets arrested for committing felony assault on someone. Arrested for. And that unfortunately and sadly, it's not shocking with this guy. And to say something's not shocking is an opinion. Like, my goodness. Plaintiff was arraigned the same day of his arrest in a lower criminal court and testified before the grand jury on October 15th, 2025. The grand jury proceeded to indict plaintiff, who was then arraigned on the indictment on October 29th, 2025. The indictment was subsequently dismissed, but the prosecution was given leave to represent. Notably, the court, in dismissing the indictment, found that the evidence presented to the grand jury, which included testimony from Hunt and the same videos referenced above from the incident, were legally sufficient to warrant an indictment, but that the cross-examination of plaintiff regarding his credibility impaired the integrity of the grand jury proceedings and may have resulted in prejudice to plaintiff. Upon information and belief, the prosecution sought to indict plaintiff again on the same charge but were not successful, with a no true bill being issued on June 22, 2026. Next, we have Blackburn's retaliatory commencement of this action. On June 24, 2026, 2 days after the no true bill was issued, plaintiff commenced this action against defendants, alleging 8 causes of action sounding in defamation, tortious interference with an existing client relationship, negligence per se, trespass to land, negligent hiring, retention and supervision, and violations of New York City Admin Code 20-409.2. Of note, the complaint alleges, among other things, that a purportedly defamatory statement was made by Tacopina and was published by NBC News. The NBC News article referenced in plaintiff's complaint can be accessed through the following website. Which article? Let's just pop this up real quick. All right, so it's an article about attorney for Fat Joe's former hype man arrested, accused of hitting process server with his vehicle. Where is Tacopina mentioned? Oh, according to Fat Joe's attorney, Joe Tacopina, it all started on March 23rd when Dixon and Blackburn sent the rapper a written demand letter seeking money for being a ghostwriter and uncredited vocalist on some of Fat Joe's songs. Fat Joe disregarded the demands, but on April 21st, Blackburn and Dixon sent a follow-up demand letter threatening to file a lawsuit not just for unpaid wages, but also for other allegations, including rape, forced labor, sex trafficking, and fraud. All claims Tacopina called false and outrageous, and said were made with utter disregard for truth or decency. As a result, Fat Joe sued Dixon and Blackburn in April, alleging extortion, defamation, and intentional infliction of emotional distress. When the process server went to hand the paperwork to Blackburn hit him with his vehicle, Tacopina alleged. And then a warrant was issued for Blackburn's arrest Thursday, according to Tacopina. The same day, Blackburn and Dixon filed a $20 million federal lawsuit against Fat Joe in U.S. District Court for the Southern District of New York. The lawsuit, and they go on to talk about the lawsuit. And then it says Tacopina has told NBC News those claims were complete fabrications designed to damage Fat Joe's reputation. And I mean, that's what they're alleging in their litigation, right? So it's something that they've claimed in litigation paperwork. So I don't see how it would be problematic for them to summarize what they're bringing forth through litigation. They say Tyrone Blackburn's arrest comes as no surprise to me. It's just the latest example of his malicious and manipulative pattern of misconduct finally coming to light, Tacopina said in a statement Wednesday. Blackburn is an embarrassment to the legal profession, and it's a disgrace watching him use the court system to shield his extortion tactics. This is why... Okay, so that says extortion. Well, this is exactly why Mr. Cartagena proactively sued Blackburn and his client Terrance Dixon in April, because he knew they intended to try to destroy his reputation by peddling salacious lies. He continued, "Today's arrest is just the first step, but I'm confident that my client's name will be cleared from all these falsehoods, and Blackburn will be brought to justice once and for all." And then let's go back to affirmation. The complaint additionally alleges that defendants tortiously interfered with an existent client relationship in connection with the DJ academics, the Abashi Fazaya and Alan Livingston, aka academics. However, a review of the docket from that action discloses that plaintiff was and continues to be counsel of record. Oh my goodness. So many cases. For the reasons set forth at length in the accompanying memorandum of law and support, defendants now move to dismiss the complaint herein as against them in its entirety and seek an award of their reasonable attorney's fees, compensatory damages, costs, and fees, and such other and further relief as the court may deem just and proper. Then we go over the rules, the sections, issue an order dismissing with prejudice and grant the costs. And this is the 27th day of July 2026. All right, so we're going to go back to the memorandum of law, which was so many documents. We were here because we left off when we finished section A. We read that affidavit. So we're going to read another section, then we'll get to if the Tacopina one is relevant here, then we'll read that exhibit. We'll break it up that way. Next, we have the captions and headlines. This is the memorandum in support of the motion to dismiss, the anti-SLAPP motion. The captions and headlines from defendant's Instagram profile, YouTube channel, and firm website are not incorporated in the complaint and are otherwise in actionable opinion. Equally as non-actionable are 1, the alleged caption of, quote, a pattern of manipulative behavior from defendant's Instagram account. 2, the alleged caption, justice is being served, from both the Instagram account and TSD firm's YouTube account. 3, the alleged headline, Joe Tacopina, quote, not surprised by Tyrone Blackburn arrest, from the TSD's firm's website. First, none of these captions or headlines have been incorporated within the complaint as the purported basis for plaintiff's defamation claims. Second, they are also clearly statements expressing an opinion and therefore not actionable in any event. The fact that the defendant held the personal opinion that Blackburn's behavior was manipulative, that his arrest constituted justice being served, and that Tacopina was not surprised by his arrest are not statements of facts, and no one reading them would perceive them to be. Next, we have plaintiff's claim of defamation regarding the NBC News publication cannot form the basis of a defamation claim against him. So that's what we just read. While plaintiff also identifies an additional statement at paragraph 131 of his complaint that he claims Tacopina made as also being defamatory, this statement was neither made nor published, in quotes, by Tacopina, and therefore cannot form the basis of a defamation claim against defendants. What's the statement at paragraph 131? All right, they're going to include it here. So rather than jump to the complaint, they say that plaintiff asserts that Tacopina made a statement to NBC News, which stated, quote, when the process server went to hand the paperwork to Blackburn, Blackburn hit him with his vehicle, Tacopina alleged. However, the statement from the NBC article is not a quotation from Tacopina, but a paraphrased statement presumably from the TMZ interview. This is apparent because the statement plaintiff attributes to Tacopina from the NBC article does not contain any quotations. We've got to define quotations for him. He doesn't get how they're used, but merely says, as alleged by Tacopina. As such, this statement is not actionable against defendant, as there's no allegation of publication of a separate and distinctly allegedly false and defamatory statement by Tacopina, rather than a paraphrased summary of previous reports. So, right, you can't make this a second cause of action because NBC chose to, like, paraphrase something. It's not a distinct defamatory statement, allegedly defamatory. And the allegations regarding the statement therefore fail to satisfy the particularity requirement. Merely paraphrasing but he doesn't know how paraphrasing works. We had the July 10th order this year, the July 10th order from Judge Jennifer Willis, defining quotations and paraphrasing and the difference to Tyrone Blackburn. So here we're citing case law that holds that merely paraphrasing the alleged defamatory statements, and see, we put brackets in here when we're modifying language within a quotation for understanding, right? We're properly acknowledging what we're changing within a quotation. That's what you're supposed to do. Merely paraphrasing alleged defamatory statements is insufficient. In the absence of an allegation that Tacopina made a statement to NBC News upon which the news report was based, the reference to a news report summary that paraphrases Tacopina's allegations cannot provide the basis for a separate and distinct defamation claim. And they cite here Riverside LLC v. Fuchs. And regardless, it was a true statement, as evidenced by the video recordings of the incident. Next, D. Each of plaintiff's defamation causes of action fail to adequately allege actual malice. And the argument here being, again, like this is public participation, public interest, it rises to that higher standard and higher standard. Added to the above noted deficiencies in the pleading of plaintiff's defamation claims, it can further be seen that they are all deficient in any event in their failure to plead actual malice. The amendment to Section 76A of Civil Rights Law imposed the requirement that a plaintiff establish by clear and convincing evidence that any communication which gives rise to the action was made with actual malice. The actual malice standard is intentionally demanding. Here they cite Saint Amant v. Thompson, quote, to ensure the ascertainment and publication of the truth about public affairs, it is essential that the First Amendment protects some erroneous publications as well as the true ones. To satisfy it, at the pleading stage, a plaintiff must allege facts showing that the defendant, in fact, entertained serious doubts as to the truth of the publication, or that she actually had a high degree of awareness of its probable falsity, which is inconsistent if you state an opinion and then you follow it up with an explanation of what you reviewed that formed the basis of the opinion you just stated out loud. That's very different than, I don't really know this source that I'm getting this from, but I hate this person, so I'm just going to spread this rumor anyway, because I don't care if it's true, right? That's a very different approach, right? So when we look at the context of the TMZ video and how Tacopina would say, like, the extortionate tactics, and then blah, 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 here's what I'm referring to, this timeline of first you want money, and then you say, if we don't give you money, we're going to add in all these other things. That's why I call it an extortionate tactic. Kind of, to me, it defeats it certainly overcomes. Like, Tacopina wasn't doubting the truth. He had an explanation for why he believed and formed his opinion. Actual malice is defined as the making of a statement that is knowingly false or with reckless disregard for the truth. It has been held that when a plaintiff's allegations are subject to the anti-SLAPP law, that the plaintiff is required to meet a higher pleading standard of establishing, by clear and convincing evidence, that the cause of action has a substantial basis in law, which requires pleading non-conclusory allegations that the defamatory statements were made with knowledge that they were false, or with reckless disregard of whether the statements were false or not. Here, there are no allegations in plaintiff's complaint that could support an inference that any of these statements complained of were made with actual malice. In fact, as explained above, each of the purported defamatory statements made by Tacopina were either substantially true, amounted to an actionable opinion, or were not in fact uttered by Tacopina. In such cases, no actual malice can be said to have been pled. Plaintiff's arguments that the pleading of facts providing a basis for concluding the alleged defamatory statements were made with actual malice has been met, because Tacopina can be deemed to have acted with actual malice during the interview, as I think that's supposed to say can't. What? Oh no, it's plaintiff's argument that he can be deemed. So we're taking issue with the argument that he can be deemed to have acted with actual malice during the interview, as he purportedly knew that the underlying facts were vigorously contested and that exculpatory electronic evidence existed, is illogical and finds no purchase in the law. It is illogical because plaintiff's arrest happened that morning and the interview was conducted later that day. Plaintiff has offered no allegations that form a basis for inferring Tacopina had any knowledge as to whether plaintiff intended to contest the charges or what exculpatory evidence might or might not exist. In any event, whether Blackburn intended to contest the charges is of no import. The argument finds no purchase in the law because a fact does not become false simply because someone contests it. People vigorously contest the truth all the time. It does not mean the truth becomes a falsity ipso facto. Further, that Tacopina reviewed videos from Hunt's efforts to serve plaintiff with the amended complaint prior to the TMZ interview support a finding that the statements were made neither knowingly false nor said with reckless disregard. And the fact that there was ultimately a no true bill issued doesn't change this. All it establishes is that the prosecution did not put forth what the grand jury deemed to constitute sufficient legal evidence to find plaintiff criminally liable for his actions. The no true bill certainly does not refute the video evidence disclosing that Hunt was struck by plaintiff's vehicle, which is what Tacopina communicated during his TMZ interview. Next, we've got defendant's communications are privileged under civil rights law, section 74. Plaintiff's defamation claims must be dismissed on the grounds that they are protected by privilege. So under this, civil action cannot be maintained against any person, firm, or corporation for the publication of a fair and true report of any judicial proceeding, legislative proceeding, or other official proceeding, or for the heading of the report, which is a fair and true headnote of the statement published. As such, it shields attorneys from liability for fairly reporting about cases in which they're involved. And the privilege afforded by the statute is absolute. Absolute. For a report to be characterized as fair and true within the meaning of the statute, thus immunizing its publisher from a civil suit sounding in libel, it is enough that the substance of the article be substantially accurate. Is this the Kesha case? What case is this? Oh, it's LexisNexis. It wants me to sign in. Boo. I don't have LexisNexis. Yeah, that was Dr. Luke. That was the Dr. Luke case against Kesha in 2023. Just a little Easter egg there. Oops. Thank gosh it took us back to the location. I thought I was going to have to scroll. Let's see. Next, we've got holding here that when determining whether a communication constitutes a fair and true report, the language used therein should not be dissected and analyzed with a lexicographer's precision. Let's see. This is consistent with the common law of libel, as discussed above, which overlooks minor inaccuracies and concentrates upon substantial truth. Further, Section 74, there's a weird indent here, applies to comments made about judicial proceedings and is not limited merely to allegations made in pleadings. While plaintiff had not yet been formally arraigned prior to the TMZ interview, this does not preclude defendants from asserting a privilege defense under 74. Arrest records have long been recognized as an official proceeding under 74. Upon reviewing the transcript from Tacopina's interview with TMZ, in conjunction with 1, the affidavit from Hunt attesting that the plaintiff struck him with the vehicle, 2, the videos from Hunt's efforts to serve plaintiff, and 3, the photograph of Hunt's leg after he was struck by plaintiff's vehicle, it can be seen that as a matter of fact, the statements made by Tacopina were substantially accurate and otherwise contained inactionable opinions, and thus plaintiff's defamation claims must be dismissed for this reason as well. Section F. Plaintiff's defamation claims otherwise fail because they lack specificity as to any special damages. So plaintiff's defamation claims, to the extent not based on allegations of having falsely alleged plaintiff committed felony assault, must be dismissed for the additional reason that they failed to identify the damages allegedly incurred. Now, if you falsely claim that somebody committed felony assault, that would constitute defamation per se, right? You can argue you don't need to go and explain it out and lay it all the way out, because if you say somebody committed a crime, I mean, it's inherently injurious. But for everything else, these other things, if it's not defamation per se, you've got to like spell out what are the special damages. So an element of any defamation claim not purporting to be based on per se defamation is establishing that the defamatory statement caused special harm. Special damages are defined as the loss of something having economic or pecuniary value. It has been repeatedly been held. They repeated that. Held that special damages must be pleaded with sufficient particularity, the failure of which would warrant dismissal for failure to state a cause of action. Here, plaintiffs' alleged damages are nonspecific and conclusory. No specifics are provided anywhere in the complaint explaining how any statements made by Tacopina resulted in an economic or pecuniary loss. Thus, to the extent plaintiffs' defamation claims are not based on allegations of false accusations of having committed a felony assault, they must be dismissed for this additional reason. All right, this one I'm interested in. When we looked at this idea that Blackburn was claiming like he's like losing business, I wanted more context here. So let's see what we get. Plaintiff's tortious interference claim fails to state a valid cause of action. So they say it's also insufficient as a matter of law. Plaintiff alleges that defendants attempted to solicit a client of plaintiffs in the matter entitled Abashi v. Livingston Allen. So they're saying, okay, so Blackburn must have claimed that Tacopina and his firm tried to get Abashi to come work with them by retaining an investigator and leaving a card with the client. And that the actions of, or maybe solicit a client not to become a client, but solicit information. That's kind of, I might have misread the way that's worded. So investigator apparently goes, leave the card. And that the actions of defendant resulted in loss of legal fees and damage to professional relationships. In doing so, plaintiff appears to be alleging tortious interference with a contractual relationship, which requires a showing that 1. The existence of a contract between plaintiff and a third party, 2. Defendant's knowledge of the contract, 3. Defendant's intentional inducement of the third party to breach or otherwise render performance impossible, and 4. Damages to plaintiff. Because an attorney-client relationship enables the client to terminate the relationship at will, any economic relations that plaintiff claims are lost requires a showing that defendant's conduct was a crime or an independent tort, as allegations of self-interest or economic motivations will not suffice. Further, it is not sufficient to allege an attempt to induce a breach. There must be an allegation of an actual breach or more culpable conduct on part of the defendant. Because plaintiff fails to plead that defendants caused anyone to breach a contract with him or allege conduct that constitutes either a crime or an actionable tort, this claim is also deficient as a matter of law. And then we saw, as represented by Peter B., Tyrone Blackburn is still counsel of record in the case anyway. So, like, what's the damages? All right, they say the negligence per se claims fail because no private right of action exists for a violation of general business law. So they're saying that this is an issue. Plaintiff alleges that Hunt was not a licensed private investigator and thus violated general business law 70, section 4, subsection 4. And because defendants retained Hunt, they are in turn vicariously liable given that his actions occurred in the scope of Hunt's employment. However, a violation of general business law 70 does not create a private right of action. So you can't sue civilly in this matter. Absent the existence of a private right of action for a violation of general business law 70, subsection 4, plaintiff cannot pursue a theory of liability under a negligence per se theory based on Hunt's alleged violation of same. So as a matter of law, this is defunct, they're saying. That cause of action is a no-go. Plaintiff's trespass claim fails because the documentary evidence discloses that Hunt had a valid basis for attempting to serve plaintiff with the amended complaint. They say this is fatally deficient. Plaintiff alleges that Hunt, at the direction of defendants, entered upon plaintiff's private driveway without permission or justification, and therefore defendants are vicariously liable for Hunt's trespass. In particular, plaintiff alleges that Hunt was without basis to effectuate service because he's not a licensed process server, and because service upon plaintiff in the Cartagena action was unnecessary due to plaintiff having waived service, and having been previously served. but the documentary evidence before the court on this motion reveals that Mr. Hunt did not commit a trespass on plaintiff's property. The elements of a cause of action surrounding a trespass are an intentional entry onto the land of another without justification or permission. Generally, service of process has been held to be a limited exception to trespass. Here, the videos reveal that Hunt approached plaintiff, who was in his vehicle and parked on his driveway, for the purpose of serving him with the amended complaint. A review of the video of the attempted service of process makes clear that at no point did plaintiff communicate to Hunt that he was on private property and request him to leave. Rather, the video evidence discloses that after Hunt told plaintiff that he'd been served, plaintiff placed his vehicle in reverse and struck Hunt's leg with his vehicle upon backing out of his driveway. Further, the notion that service of the amended complaint upon plaintiff was unnecessary and done to intimidate plaintiff is without basis. Plaintiff's claims that he waived service of the amended complaint is flatly contradicted by the email correspondences from plaintiff himself, and I'm excited to read these, where he made clear that service would be conditionally waived only if defendants agreed to an in-person meeting with prosecutorial authorities, further to his disputed allegations of criminal activities by Cartagena. Defendant refused that conditional offer, and the docket from the Cartagena action otherwise confirms that no waiver of service was ever filed by plaintiff. If you're going to waive service, it needs to be on the record. Second, plaintiff's claims that he was already served with the amended complaint contains misstatements of law and ignores that it was plaintiff's duplicity that resulted in Hunt's retention to serve plaintiff with the amended complaint. Specifically, plaintiff alleged that he was already served with the amended complaint through the New York Secretary of State. However, service through the Secretary of State in the Cartagena action applied only to Blackburn law, and not plaintiff in his personal capacity. Thus, while plaintiff may have received a copy of the summons and complaint forwarded from the Secretary of State, that would have only been sufficient to obtain jurisdiction over Blackburn law, not plaintiff. Further, efforts were made to serve plaintiff as evidenced by the affidavit of service being sworn to by Mineta, wherein he attested to making 3 attempts to serve plaintiff in accordance with CPLR 308-4. By affirming the amended complaint on May 7, 2025, and mailing a copy of the amended complaint. However, plaintiff proceeded to email defendants and Reed Smith on May 8, 2025, and we got a big part of these quotes in the affirmation, so maybe we won't skip over and look at them, because we got all the meat and potatoes. One day after the amended complaint was posted, and falsely assert that he and Dixon were not domiciled in New York, and because of this, defendants had not substantiated diversity jurisdiction. Rather than litigate the validity of the service made by Mineta, Reed Smith contracted with Guidepost in furtherance of effectuating service of the amended complaint by enhanced service, so as to avoid any further gamesmanship on the part of plaintiff. Thus, plaintiff's affirmative conduct is misleading defendants by claiming that the service address was not his domicile. Not only was a valid basis that justified why Hunt was retained to serve plaintiff with the amended complaint, it should also stop plaintiff from asserting a trespassing claim against defendants. Had defendant simply been honest about his domicile, the need for Hunt to serve plaintiff with the amended complaint would have never occurred. Lastly, Hunt was, those correspondences saying like, I'll waive service if you meet me down at Homeland Security. Like, to me, that is gamesmanship, so. Lastly, Hunt was not required to have a process server's license because he's not effectuated service on 5 or more persons in the calendar year prior to May 12th, 2025. New York City Administrative Code 20-403A states that it's unlawful for any person to do business, be employed as, or perform the services of a process server without a license. However, 20-404C provides that the service of 5 or more persons in any one year shall be deemed to constitute doing business as a process server. As Hunt did not serve process on 5 or more persons, he is not deemed to be doing business as a process server and thus not required to have a license. I think someone was in the chat like spelling out the last stream we got together where I was like, well, maybe there's like criteria, questions, a threshold, something more to this. Something more to this. And someone in the chat was like, it might have to do with like how much activity you have. And here you go. Here you go. So if this is the correct representation of what these codes state, there goes that argument. All right, next up, actually, should we go to the Tacopina thing? I think we're kind of at the end of the motion. When they're going to get through two more. And then the request of remedies. Let's breeze through this and then let's do the Tacopina affidavit. So plaintiff's negligent hiring, retention, and supervision claim fails to state a cause of action and must be dismissed. This is in relation to the hiring of the process server. They say plaintiff fails to allege either that Hunt was an employee of the defendants or that there was a known propensity to engage in misconduct that was ignored. So both required to bring this cause of action. Initially, this claim fails because there's no employer-employee relationship between the defendants and Hunt. In fact, not only was there no employer-employee relationship between them, defendants never even retained Hunt. Rather, Reed Smith contracted with Guidepost to effectuate service of process of the amended complaint. So they hire a company and then the company selects Hunt. As defendants did not employ or retain Hunt or Guidepost, there's no actionable claim for negligent hiring, retention, or supervision because there can be no nexus between defendants' reported negligence in hiring Hunt and plaintiffs' reported injuries if defendants never hired Hunt in the first instance. As defendants did not employ or retain Hunt, they had no duty to plaintiff to ensure Hunt performed service in a manner that would be expected. Further, plaintiff's complaint is also devoid of any allegations that disclose the nature of the conduct that Hunt had a propensity for which defendants allegedly should have been aware of and taken steps to prevent. So, what is the conduct, right? In this first argument, we're accepting at face value that there was some negligence, some misconduct. But then they're arguing here, there aren't even allegations of such. What's the conduct that, had we had this employer relationship, we were supposed to take steps to prevent? The complaint alleges that Hunt is not licensed as either a private investigator or a process server, but even assuming the allegations in plaintiff's complaint in this regard are true, which we just saw addressed above, Hunt being unlicensed as both a private investigator and a process server are not indicative of Hunt having a propensity for any particular conduct, nor does anything in Hunt's prior history as a special agent in charge with the Drug Enforcement Agency indicate that he had a propensity for any particular conduct in connection with Hunt's alleged stakeout of defendant's residence in his efforts to serve plaintiff. Thus, the 12th cause of action must be dismissed for this reason as well. Then a violation of city admin code does not create a private right of action. Yeah, so there we go. You're saying that we'd violated a city administrative code. They say that 40.92 allows for a private right of action as against a process server or a process serving company by any person injured by the failure of a process server to act in accordance with the laws and rules governing service of process in New York State. Defendants are not a process server or a processing company. So you can't bring, as a matter of law, they're saying you cannot bring this type of cause of action against a party that's not these individuals. They aren't serving process. So I wonder if this cause of action in the separate lawsuits of the three that are where the defendant is Hunt and the process serving company, maybe we'd see different responses from them in response to this cause of action. But here for Tacopina and the attorneys, they're like, this is a matter of law, cannot apply to us. So plaintiff attempts to classify defendants as a process serving agency based on the incorrect allegations that defendants retained Hunt. However, besides this being factually inaccurate, attorneys and law firms are explicitly accepted from the definition of a process serving agency. And then they cite the code, they cite 404B. Oh man. Let's see. And again, that's LexisNexis, so I can't just quickly open that. I don't have an account. But you could just search. If you want to do a quick Google search, just type NYC admin code 20404B. Well, thus plaintiff's claim is not actionable. And then they say, plaintiff's conduct exemplifies the type of retaliatory litigation that New York's anti-SLAPP statute was designed to deter through dismissal and a fee award. So for this reason, it's respectfully submitted that an award of defendant's reasonable attorney fees should be awarded. Where a plaintiff in a SLAPP case fails to establish a substantial basis for its claims, the statute provides that attorney's fees shall be recovered. I love a good shall. They italicize it here. They add the emphasis on the shall. And that's directly from civil Civil Rights Law 70-A1A. And they got case law that says plaintiffs that supports this as well. Plaintiffs' defamation claims have no substantial basis in fact or law, warranting entitlement to an award of their attorney's fees and costs in being compelled to litigate these frivolous claims. In fact, this action is the exact type of action that 70A authorizes for the recovery of compensatory and punitive damages. So they're saying if this type of protection is not meant for this case, then what case is it made for? This is the exact perfect example of what this is designed to protect against. Compensatory damages under 70A1B may be awarded where the claims were brought, quote, for the purpose of harassing, intimidating, punishing, or otherwise maliciously inhibiting the free exercise of speech, petition, or association rights. And 70A1C allows punitive damages where the claims were brought for the sole purpose of the same. The complete absence of factual or legal support for the claims asserted demonstrate that they were not brought in good faith to seek a remedy through pleadings, but to harass and publish defendants for protected speech. So for the foregoing reasons, the defendants respectfully request that the court dismiss the complaint herein with prejudice, award defendants their attorney's fees, costs, compensatory damages, and punitive damages, and grant such other and further relief as the court deems just, equitable, and proper. And that's signed off here by Peter B. And I guess William Knox. I thought that was like the name of a building maybe, but maybe that's an attorney. I think we got 2 attorneys there. And they sign off that this meets the word count requirement, all of that criteria. All right, we did it. We got through the memorandum of law. Let's go to the Tacopina affirmation. It's only 8 pages, but included is a good amount of exhibits. All right, so when did he sign off on this? Because the date was blank in Peter's affirmation. All right, so this is the 24th day of July, 2026. So did he write this? He probably spit this out and handed it to Peter, like, do some magic with it. All right, so Tacopina, under, penalties of perjury. He's an attorney duly licensed. Submits us in support of the motion to dismiss under New York's anti-SLAPP law. And in support, we have a bunch of exhibits we're going to look at. The TSD firm was retained by Joseph Cartagena to commence an action against Terrance Dixon, Tyrone Blackburn, and Blackburn's law firm, TA Blackburn Law, after the making of a number of defamatory statements by Dixon against Cartagena. And I could zoom this. And after Cartagena's personal counsel, I think that's Erica Morera, received demand letters from Blackburn containing highly incendiary and false allegations against Cartagena. Formerly retained by Cartagena as a hypeman from 2006 to 2019, Dixon began making defamatory statements against Cartagena in 2023 through social media. Do they attach that as Dixon? I think they just cite to the complaint, which cited those as exhibits. So, but we got a preview of that on this stream. You don't need to go back. We got a little preview of some of those claims just from the Blackburn Instagram posts, or the post by the account Tyrone_Blackburn. After finding no success in pressuring Cartagena to make payments to him to discontinue the smear campaign, Dixon subsequently retained Blackburn, who sent a demand letter dated March 23rd, 2025, the first demand letter, claiming that Dixon co-wrote approximately 80 to 90% of the lyrics on multiple Fat Joe albums, and threatening to commence litigation if a resolution was not reached. So let's we'll pull up quick this Exhibit B. All right, so this is lengthy. They send a 15-page demand letter, and remember in the deposition, this was just looking for friendly conversation, not looking for money. This says, please be advised that this firm represents Terrance Dixon, and this is formal notice of representation and a demand for immediate corrective action. And I believe during the deposition, I think Tacopina was trying to read this language, and Blackburn either said he couldn't see what was on the screen or whatever a detour or deterrent or deflection came about with that. So they go through this lack of credit. It's all about the songs. This is all about the songs, contributions, presenting works, not giving payments, talking about relevant or maybe not really relevant laws and acts. All about the music. The point being that there aren't any claims of this like salacious sexual assault allegations at this point in time. This first demand letter completely devoid of such things, right? So that's the context there that's important. When this first demand letter was not responded to, a second demand letter, later dated April 21st, 2025, so about a month later, was mailed to Cartagena's personal counsel, Erica Juliana Moreira. The second demand letter not only doubled down on the false claims of Dixon being a ghostwriter for several of Cartagena's songs, but included a draft complaint, which contained a claim that Cartagena violated the Trafficking Victims Protection Act, TVPA, and included allegations that Cartagena had sexual relations with 3 minors. Given both the nature of the claims alleged in Blackburn's draft complaint and a threat made by Blackburn to report Cartagena to Homeland Security, Ms. Moreira had a telephone call with Blackburn on April 23rd, 2025. And I think this is going to be glorious because I've tuned into hearings when there's a public listen-in line that you can call in. Some of them have had that option. And there was one hearing where Tyrone Blackburn, I think I posted like a Twitter thread about what happened at that hearing, so it would be fresh in time to when I listened to it. I think it was back in January of this year, so several months ago. I don't have the best recollection on the fly, but Blackburn did raise an issue that he wanted to go down to speak with prosecutors and file a complaint, hoping it would cause a criminal charge to come forth against Erica Moreira for like criminally legally recording him without his consent. And he insisted that she was in Florida at the time and that's a one-party state. And I don't know if it was in that same hearing that like Ian Turetsky and other counsel from Reed Smith for Fat Joe were like, it's New York, but no, she didn't. But that's what his perspective was. And he started to say, like, this is not a game to me. This is not a game. And he was so bothered by this purportedly criminal recording by Erica Moreira of one of these phone calls from April 2025. But it's going to get good. It's going to get good. So bear with me. Pin this context here before we get to the exhibits that are now part of this filing. So they say that Miss Moreira had a telephone call with Blackburn on April 23rd, 2025, which conversation was transcribed in an effort to understand why Blackburn was threatening to report Cartagena to Homeland Security and to obtain additional details regarding the TVPA claims. See Exhibit D. We're going to read this, and then we're going to look at the transcript. During this call, Blackburn explained that he intended to call Homeland Security because Dixon had learned from an anonymous source. Right? So remember, we are here today to look at Tacopina's motion to dismiss the defamation lawsuit against him filed by Tyrone Blackburn, where Tyrone Blackburn saying like, hey, you went and talked to TMZ, you made false statements, and you had no basis for it. But working backwards to the issues that started this all. This pre-litigation, these demand letters, and then the filing by Fat Joe of this lawsuit against Terrance Dixon and Tyrone Blackburn. Blackburn saying that his reason for wanting to call Homeland Security is because his client tells him that an anonymous source told him something, that Cartagena had put a hit on Dixon. That's where we're basing these actions on? Upon Miss Moreira asking for more details, Blackburn admitted that Dixon had not shared the identity of anyone that had threatened his client, or that the sources in connection with that, and that Blackburn took Dixon at his word. No pre-investigation, no vetting. Blackburn further admitted during this conversation that he had no intention of filing on behalf of the 3 Jane Doe minors that were identified in the draft complaint, and that Dixon's potential claims were not about Joe's decision in the bedroom with whomever he chooses to sleep with. This is business. And they're citing to the transcript. 2 days after the phone call with Miss Moreira, Blackburn sent a third demand letter dated April 25th, 2025, reiterating that Dixon intended to pursue TVPA claims against Cartagena in addition to his claims of uncredited royalties, and made a settlement demand of $20 million, with the response demanded the same day. Do you think there's a reason Tyrone Blackburn's panties were in a bunch about that phone call with Erica Moreira? Because Dixon and Blackburn continued to threaten litigation based on knowingly false claims, and given the unsettling nature of the defamatory statements made by Dixon against Cartagena, the TSD firm and Reed Smith were retained and proceeded to commence the Cartagena action by filing a complaint in the Southern District of New York on April 30th, 2025, which was subsequently amended on May 1st, 2025. As a professional courtesy, I reached out to Blackburn. This is Tacopina. I reached out to Blackburn to let Blackburn know of the filing of the lawsuit and to try to make arrangements for service of process without the need to retain a process server. Shortly afterwards, Blackburn sent email correspondence stating he will gladly waive services for any BS lawsuit your pedophile client wants to file against me, and I'll gladly meet you at the Southern District of New York prosecutor's office to file your extortion claim. As this indicated the offer to waive service was premised on meeting Blackburn with prosecutorial authorities, Reed Smith contracted with Court Support, Inc. to service Blackburn with the summons and amended complaint. In furtherance of their efforts to complete service upon Blackburn, process server Vincent Mineta affixed the amended complaint at the address. So we heard about all this. Then they get this May 8th. He's copied on an email from Blackburn where he represented that this address was not his domicile, that he wasn't domiciled in New York, and reaffirmed that his prior offer to waive service of the process of the AC was conditioned on meeting with Blackburn, Homeland Security, and the Assistant U.S. Attorney's Office for the Southern District of New York. Considering that Blackburn asserted that New York was not his domicile, thereby making it evident that he was going to challenge the court's jurisdiction over him in the Cartagena action, along with challenging subject matter jurisdiction, it was decided between the TSD firm and Reed Smith that renewed efforts were needed to effectuate service of the amended complaint on Blackburn. Thereafter, acting at the request of Reed Smith, James Hunt proceeds to effectuate the service, where Blackburn was personally served on May 12th, 2025. Neither I nor anyone else at the TSD firm retained Hunt or otherwise communicated with Mr. Hunt prior to the May 12th, 2025 incident with Blackburn. Rather, Reed Smith had contracted with a third-party vendor called Guidepost Solutions, who in turn assigned Mr. Hunt to serve Blackburn with the amended complaint. Yeah, because there's been this allegation made by Tyrone Blackburn that this was all some grand conspiracy between like Reed Smith and Mr. Hunt to bring him down because he's an advocate for survivors of sexual violence, and they wanted to silence him. And this was all a grand scheme to do so. But here, Tacopina is representing, I never even contacted the guy. And even Reed Smith went to a company, and the company, like, picked this person that's in their directory, their Rolodex. Then Tacopina says, I learned about this incident between Blackburn and Hunt from a review of the affidavit of service sworn by Hunt. So, you know, what do you think is better to rely on? Someone telling you an anonymous person told something and you just take them at their word and they don't tell you who the anonymous person is or give you any context about it. If you're doing that to send demand letters and ask for $20 million versus, hey, I read a sworn affidavit of service and that started to form my basis for what my knowledge of an incident is, and I use that information to form an opinion, which do you think is a better approach? And then they say also a separate affidavit sworn to by Hunt, wherein he stated that he believed Blackburn struck his leg with his vehicle in the context of an effort to evade service of the amended complaint. I also reviewed 2 videos that were taken in connection with Mr. Hunt's service of the complaint upon Blackburn, along with the photograph taken of Mr. Hunt's leg immediately following the May 12th incident. In reviewing the videos, I observed that upon Mr. Hunt seeking to serve Blackburn with the amended complaint, as Blackburn sat in his car in the driveway of his home, the vehicle moved to back out of the driveway. I further observed that Mr. Hunt appeared to move once the vehicle was placed in reverse in a manner that indicated that he'd been struck by the vehicle. I further observed in the second video that Mr. Hunt's left leg had a gash as a result. Shorty. We have a typo here. It says shorty instead of shortly. Shortly after Blackburn's arrest, arising from this incident, TMZ requested if I would do an interview regarding Blackburn's arrest, considering that I was lead counsel for Cartagena in the Cartagena action. The full interview that I had with TMZ can be accessed through TMZ's website, and they link to it. During my interview with TMZ, he has his own category on TMZ. Look at this URL. It says /people/Joe Tacopina /videos. During my interview with TMZ, I responded to a question stating that the word allegedly could be taken out of a question regarding Blackburn driving over your process server. The statement was based upon my review of the videos referenced above. I also stated during my interview with TMZ that Blackburn was arrested for committing felony assault, which I'd learned occurred through conversations with a representative of Guidepost. In fact, publicly available records confirm this was true. During the course of the remainder of the interview, I expressed my opinion that Blackburn's arrest was just the latest example of his malicious and manipulative pattern of misconduct, that Blackburn's an embarrassment to the legal community, and that it's a disgrace watching Blackburn use the court system to shield his extortionate tactics. While not kind, I can only say that these are opinions, that I formed of Blackburn based on my observations of how he's conducted himself, both prior to and upon commencing the Cartagena action, including researching Blackburn and seeing the several times he was admonished by courts, including U.S. District Court Judge Denise Coate, where she stated that a reasonable inference from Blackburn's pattern of behavior is that so it's a reasonable inference, so can it be a defamatory statement? Oh my god, this decision is golden. This Denise Coate decision is a gold mine. Not just for Tacopina, but really any other attorney who wants to be able to, like, raise a concern with Tyrone Blackburn as opposing counsel. They say a reasonable inference from Blackburn's pattern of behavior, it's his own conduct that gives rise to the reasonable inference, is that he improperly files cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressure defendants to settle quickly, including a disturbing allegation where Blackburn referred to his adversary as a disgusting racist merely for disagreeing about the selection of a mediator, resulting in Judge Coate referring Blackburn to the grievance committee. And U.S. Judge Paul Otkin, where Blackburn was, this is like that whole long footnote that we had cited. So we go through all that, guys, in the earlier part. Unfortunately, these opinions have only been reinforced during the course of litigation during the Cartagena action, including his outrageous and offensive conduct during Dixon's deposition, which resulted in Blackburn being sanctioned and again referred to the grievance committee, with a footnote that says, this conduct included referring to Chad Siegel of the TSD firm as a piece of shit, asking what date's your transition surgery, and stating your mother's an alleged criminal. She should have spit you out instead of swallowing, and calling myself Taco Face. Wherefore, defendants respectfully request that the court issue an order dismissing with prejudice and for fees, costs, and other relief that the court deems just and proper. So there we go. That is Tacopina's affirmation. All right, and then we've got, let's see. Before we do this phone call transcript, because that's long, we might do a second stream for that in full, but we'll do a little teaser of it at least if we don't do the whole thing. Let's see. That's the transcript. I wanted to pull up the email exhibits relating to that, like, April time period. Aha, this one. So, and before I did this live stream, /star and I, we were having our conversation over on an X thread in the replies. And, like, at the same time, he, like, posted something in an email, and it related to something I was already thinking. And here we go. So these emails are like, all right, this is where I'm giving this conditional waiver of service. Is this reading bottom up or? All right, so 1:25 p.m. and 2:01 p.m. Okay, so this one's first. Now, this blew my mind to see this written. So Blackburn wanted Erica Moreira criminally prosecuted for recording this one particular conversation where he seemingly admits that he didn't vet his client's claims before sending out these demand letters and sending a draft complaint that he was planning to file that same day if the monetary demands weren't met. He wanted, this is in January of this year, was raising hell, saying he wanted her criminally charged for illegally recording him. And then what does this email say? And when I was listening to that hearing, I didn't know about this verbiage. I didn't know about this email. But I think it's possible that, because it was really Judge Rochon and Blackburn speaking for most of that hearing. But look at this. It says, this is Blackburn writing, extortion? I'm the wrong person to play this game with. I have recorded every conversation with Erica. You can keep quoting Denise Coates all you want. That judge that said a reasonable inference would be that he files this pattern of his conduct. But I've done my due diligence, and it is clear you've not. I will file suit today. Let me know if you will waive service of process. Regards, Tyrone Blackburn. To me, this is crazy. This is crazy. This is seeing gaslighting behavior in action. I don't like to use the term gaslighting for every little willy-nilly thing. But you've got this attorney raising his voice at Judge Rochon, telling her this is not a game, describing, he's like, he seems like he's like, again, it's a listen-only line. I can't see a video. But it seems like physiologically, he's like really worked up. Pissed. In January of this year about Erica Maria recording his call back in April. And now we have additional context I'm learning through these filings that one of those April calls is where it sure seems like he makes the concession that he didn't do any vetting. And here this emails him, it seems like he's responding to something. Someone's telling him what you're doing is extortion. And then he's like, I've recorded everything. But you're saying you're not domiciled in New York. So if you're going to make the argument, well, it's okay for me to record because I know I'm in New York. But you're also, a few days after this, avoiding service of process. I'm not there. I don't live there. I'm not even in New York. Well, then maybe you have a one-party, two-party state issue with your claim that you're recording. And yet you put forth a representation, a totally baseless representation, to Judge Rochon that another attorney, Erica Marrera, was committing a criminal act because you just know she was in Florida when it's disputed and you're being told, someone from opposing counsel saying that no, she was actually in New York, which is one party. But then you have this email. It to me, it's just so wild. It blew my mind to see this email. But anyway, it seems like he's quoting himself and then sends an additional correspondence saying, you know what is glaringly obvious, and what's this, like 15 minutes later? No, okay. It's like 35 minutes later. You know what's glaringly obvious from your joke of a letter? 1, no mention of my client or his claims. 2, no denial of your disgusting pedophile of a client sleeping with children. 3, no denial of your client's henchman, Pistol Pete, threatening to pound out my client. You don't know who you're threatening, Mr. Tacopina. I will gladly waive service for any BS lawsuit. We've seen this part quoted. Let me know what time. I'll be sure to walk up with the 19-minute recorded call of Pistol Pete trying to set up my client to be killed on behalf of Mr. Cartagena. I will walk with the complete recordings of Nikki and her cousin, which detail how your disgusting pedophile client solicited and manipulated a 10th grader into performing sex acts, not to mention all the other crimes your client has personally committed or commissioned. This will be fun. Regards, Tyrone Blackburn. Mr. This is not a game says this will be fun. So that's interesting. And then we have this April 23rd, 2025 call transcript. So first off, we have Tyrone Blackburn saying, hello, Tyrone speaking. May I help you? Hello. Erica says, I'm sorry, who's speaking? Tyrone says, this is Tyrone. Erica says, oh, I think you have the wrong number. Tyrone, well, I don't know who you're trying to reach. Erica says, what is your name? Tyrone says, Tyrone Blackburn. Erica says, oh, hi, Tyrone. Sorry, I thought I heard something else. This is Erica. Tyrone Blackburn says, oh, no. And then it says indiscernible. Erica says, this is Erica Morera. I work with Fat Joe. Tyrone says, how are you doing? Okay, how are you, Erica? Erica says, I'm doing well. How are you? I'm good. I'm good. I'm just closing my door so that way the street noise won't mess up. We won't hear the background noise, so I'm fine, yeah. Erica says, okay, well, thank you for making some time to speak with me. Obviously, we are taking this very seriously. Of course, my client denies the allegations in your complaint. I guess I just want to start by asking why you're threatening to call Homeland Security. She gets right into it. She gets right into it. Oh my goodness. Crazy. You may know, Tyrone Blackburn. Well, I think that when someone receives a death threat, like I take that very seriously. I had that happen with every single case that I've had, and I've always called. What? Is he saying he had so many cases, his own words or whatever? Is he saying that in every single case he's had death threats and he goes to Homeland Security? Every case? That's gotta be hyperbole. That can't be a serious claim. He says, I've called Homeland Security against Sean Combs when he threatened Lil Rod, and now he's in prison. I've done it against every single person, and then I just filed a lawsuit. I don't wait. I don't. But that's not the reason Sean Combs was put in prison. Is he saying that his call to Homeland Security is why Diddy was raided and arrested? What did we just start reading? What did we just get into? He says, I've done it against every single person, and then I just filed a lawsuit. I don't wait. I don't. This is crazy because it's like, if we take this in a circular way, with the context that he's not vetting these claims, he's just taking a client at the word. He's saying every single time I'm about to file something where we know in this instance his own words are going to show in this transcript somewhere, he's going to say, I took him at his word. He's saying every single time before I file that litigation, I call Homeland Security on whoever the person is, and they get arrested, implying that they get arrested at his behest, at his report, because of his report. Maybe you should wait. Maybe you should vet. Use that time wisely. He says, I had another. He's about to go brag. The reason why Lil Rod's case was filed as rapid as I did was because I had a conversation with Jonathan Davis. And then by midnight, Sean Combs called through someone else and threatened my client. And I filed within a couple of hours after that. And I called Homeland. What does this have to do with Fat Joe? Erica says, so Blackburn says, I did the same thing for everyone. T.I., Tiny, everybody. I don't play those games with those threats. I don't. Erica says, well, yeah, of course death threats are very serious. How did your client receive a death threat? And when was that? Tyrone Blackburn. Well, he was told by people in his community in the Bronx that their client had came around. I think he's in New York right now. But you're not in New York. I think he has a house or something in New Jersey. And he came around at nighttime and he offered them, I believe, $50,000 to put a hit out on TA. And they were trying to get TA to come to some home or something where that hit would have taken place. And the reason why my client takes this very seriously is because, he's, as you know, he's known your client for a very long time. It was for over 10 years. And he's been present when your client has made similar asks, and he's put out similar things against other people. And, there's a lot of folks whom, and I don't know if this is the right conversation to be having this, because I don't want to implicate your client in anything. What? You've already sent demand letters. What do you mean you don't want to? I don't want to implicate your client in anything. But there are some things that my client shared with me. If you're not willing to implicate a client, why are you willing to take a report of a threat to Homeland Security about them? But there are some things that my client shared with me with an individual who's currently sitting in prison on a life sentence for something that your client was involved in. there was there's a lot. I'm not naming any names. I'm not putting anything out. But, my client is justified. Let me just say that he's justified in being worried that something is going to happen to him based on him being around your client for a very long time and based on seeing how your client moved in the past and from what he was told and from what was told to him by the individuals, plural, that said it. Erica says, can you share who these individuals were? Because my client is just as concerned as yours. Tyrone says, well, he's not giving me permission to give anyone's names. He just told me that, that he was called and he was given a warning that this is what your client is doing. And that's why I sent out that email. I told him I would try to put an end to it right away. So that's what I did. I don't think that he's going to lie to me just because he's not making, he doesn't everything else. I don't even know if I can take at face value that Terrance Dixon actually spelled all this out the way that Blackburn's representing. So even if we take at face value that Dixon did say all of these things that Blackburn's relying on, there's an issue because Blackburn didn't do any vetting, didn't even care to know the names. But can I even bring myself to a point where I can conclude that Blackburn's being honest here in his representation that Dixon even told him all of these things? Because we just heard him say that he reports every single person for his clients to Homeland Security. And I think that was extremely hyperbolic at best. So this to me is stuff that if I was Dixon and I wasn't doing this, I wasn't saying these things, and Blackburn was going rogue with his representations through these emails, this would go to my defense as a defendant, as a named party in Fat Joe's lawsuit against me. And that goes to the whole conflict of interest for Tyrone Blackburn all of this time, I think, to have been representing Dixon. But Dixon in his deposition, it said like he seemed like nobody else would take his case besides Blackburn. But to me, this is crazy. This is wild because I don't even trust that this is really what his client was telling him. I think he could just be saying all of this on the fly to excuse why he was saying certain things in written correspondence after the fact. But yeah, he goes on, he's like, everything else, everything he's named, that he's provided me, and all the claims that he's raised, I've spoken to people who've corroborated it, including those girls, and all the other stuff that's inside of that complaint. So, it's not a matter of, me not believing him, because his word has been very solid since the beginning of me talking to him. So, the fact that he doesn't want to implicate someone or put anyone's name out there because he hasn't, but you're threatening to file. What do you mean? He doesn't want to put either he doesn't want to put anyone's name out there or you're lying right now. Because we wouldn't have these communications with the demand letters. And if you don't do this, I'm going to file within 4 days. Or if you don't do this, I'm going to do this today after this call takes place. So are you saying that these threats to file a complaint were contradictory to what your client wanted to do? I think this is really problematic. He just says, I take him at his word that this is what he received. He's not a guy that runs scared from anything. He just wants me to know what happened. He didn't even want me to say anything. And I said, no, I have to say something. So you're saying your client didn't want you to do this? This adds so much, like, I thought it was a well-written complaint from Fat Joe anyway. I think it was a good basis to bring like a defamation case forward. But this adds so much context. And again, Tyrone Blackburn's an attorney doing this. He's not just like a random person. He's an attorney. Who's saying his client didn't want him to say anything. And I said, no, I have to say something. If something happens to him, I'm liable as his counsel to try to put an end to these things if possible. So that's why I reached out to you. But he's not given me the name of the person that told him. Man, I think Dixon might have said some stuff during his deposition, but I think Dixon has a good defense to actually blame his attorney based on the words here. And again, Tyrone Blackburn's words here could all be lies. He could be making this up as he's having this call just to blow smoke at Erica Moreira. But he's still saying it, and now it's transcribed. We've got a record of it. So if I was Dixon, I would be all over this. He says, so that's why I reached out to you, but he's not given me the name of the person that told him. Erica says, understood. And for the record, it's absolutely not true that my client put a hit out on your client or anyone for that matter. So, this is a very scary situation for my client because, he does have a criminal record and you're threatening to call Homeland Security. So what exactly is your client looking for? You and I are speaking today, and I just want to understand what will get this to, a satisfactory resolution. Blackburn says, I mean, listen, Homeland Security and all that stuff aside, all that stuff aside, nothing. The whole resolution of this before my client's call yesterday to me and my email to you, my goal was to see if we can have some sort of resolution to the claims that my client has regarding what he feels to be, his contributions that was not compensated and, work and all sorts of stuff and time and all these other things that he feels that he was not compensated for. Because he spoke with former managers of your client, most recently in 2024, who said to him, oh, listen, this is what these concerts were funded. This is the budget that was given for the hype person. You should have been paid between $3,000 to $5,000 as a hype man because it was budgeted for it and the promoters paid for it. But my client was getting paid $250, $300, or $500 per show, which is, which is way less than $3,000 or $5,000. Then you have the issues that I laid out with the TVPA stuff. I mean, your client, according to my client, has recorded my client having sexual intercourse with a whole bunch of different women at your client's request. My client wasn't the only person who was called into the room to service or to perform sex acts with women. There was another individual who was also called in. And this just seems like to me of like we're transferring the Diddy accusations to someone else's cause of action. Erica asks, have you seen these? Have you seen these videos? Blackburn says, I personally have not seen them, but I've definitely seen other videos where your client's voice is heard in the background, where my client is engaging in sex acts and your client is behind the camera. What's interesting is he's so confidently identifying a voice here, but when Terrance Dixon was being deposed, and he was asked about a podcast interview where he guested on On the Books podcast. He said he can't tell if that was his voice, and Tyrone Blackburn was chiming in and back and forth. They're like tag teaming, like it could be AI. We don't know if that's his voice. But here, oh, I know. I didn't see these videos, but I know it was his voice in this other video I heard. So pick and choose when you want to identify a voice and attribute it to someone. And they say your client's behind the camera or someone's behind the camera, but your client is in the room. So I've definitely seen those videos. But the videos of that your client took without my client's knowledge is on the phone. And I put the number, I believe I put the last 4 digits of the number in the complaint. I spoke with this woman named Nicole, who was, I think she's Norwegian at the time. She has, long black hair, blue eyes, and I think she's married to a baseball player or something like that. So I spoke to her, I spoke to Nikki, I spoke to Nikki's cousin, I spoke to a few other individuals. There's a gentleman named Mateo. Erica says, sorry, but are Nicole and Nikki the same person? Blackburn says, 2 different people. Moreira says, oh, it's 2 different people. Blackburn says, so Nicole's she's Norwegian. She was flown to the United States on multiple occasions by Joe when she was 16 years old, flown to other European countries while he was on tour in Europe, and I believe he paid for her to get a BBL out in Miami. Nikki, on the other hand, is someone that he was with for a very, very long time. I met up with her and her cousin, who Erica says, I'm sorry, he paid a BDL? Blackburn says, yeah, a Brazilian butt lift for Nicole, the blonde girl with the blue eyes. What? You just said she had long black hair. The blonde girl with the blue eyes, but we just said long. Am I blind? Okay, whatever. Now we're describing her differently. Erica says right. Blackburn says, yeah, she has long black hair. Sorry. Okay, he corrects himself, not blonde hair. And blue eyes. She's from Norway, and apparently Joe took her virginity when she was 16 years old, and he took her friend's virginity too, two 16-year-olds. And, listen, my goal is not to make this a thing, I always try to resolve these things privately and quietly, and, do whatever. I've solved many of these cases without me having to file anything, But, some of these cases, you have people who are high on drugs, like T.I. and Tiny, or like Diddy, and, they can't really see the writing on the wall. So, they make stupid decisions. But, again, my goal is not to try to hurt your client or harm your client. But it's definitely to try to make my client whole because, he has, documented losses, which he was corroborated by someone who was a personal manager of your client. And, Erica says, sorry, you made reference to that in the draft complaint that you sent as well. Just 2 questions. Do you have Nikki's last name? I'd like to have some information to go back and talk to my client. If you have any specifics you can share with me. Blackburn says, I don't have Nikki's last name. I do not have Nicole's last name. But I did speak with them, and I spoke with her cousin. I spoke to Nikki's cousin, and Nikki's cousin was 15 at the time, actually, and was telling and gave me a whole entire detailed rundown of how they met, where they met, how long the relationship went. And there's this Dominican woman from the Bronx who was also 16. She can't really speak English that good, so, I really couldn't understand what she was saying. But, long story short, I mean, there's just, it's just not, it's just not good. Erica says, well, yeah, it's these claims are, like I said, they're very scary. And, of course, my client denies these allegations. So, Blackburn, of course. Listen, I would never tell him to admit it. I mean, he would never admit it unless you show him in his face, like, hey, this is it, right? And this is not you. Even then, I've had people deny it even then too. So, and then it says indiscernible. Erica says, well, do you have? And Tyrone says, yeah, I would never expect your client to admit anything, Erica says, do you? Tyrone, I'm not asking him to admit anything. Erica, do you have any witness statements? Or Tyrone says, I have witness statements provided. Erica says, last names of any witnesses? Tyrone says, I've spoken to many people who my client put me on the phone with who provided me with statements. They've not given me permission to turn anything over. I'm calling this sounds like BS. If you're leading with, I spoke to people over the phone who provided statements, and you don't have last names, and some of his wording saying he doesn't know the last name. At some point he's worded, I don't want to give that out. But other times he says, I don't know their last name. You don't have a written statement from somebody if you don't know their last name. I know that's going to be your next question, but I can confirm with you that I spoke to these people. Spoke to. Like, I'm not bluffing about what I'm telling you and about what I've heard myself and about what I've seen myself, Like, this is not something that, I'm just pulling out of thin air. Because if I file the lawsuit, I'll have to corroborate it, which is why you're trying to settle. This is saying the quiet part very loudly. If I file the lawsuit, then I'll have to corroborate it. And I'll have to produce everything and prove it, And remember, there's been discovery issues. Fat Joe's team was like, hey, we requested these specific things that he's referenced, and he still hasn't turned them over. After months. He keeps avoiding requests to meet and confer about discovery issues. You have to keep calling the court in. Judge Rochon was getting called in to referee. So, taking this wording with the context that discovery was problematic, wouldn't you be rushing? If you really have these claims, wouldn't you be rushing to file this discovery? It can be filed under seal. It doesn't need to be filed on the public docket where I can go and do a YouTube stream about it with you guys. But wouldn't you be like, hell yeah, let me put this either in an argument that I need when they say I don't have it, or they're still waiting for it, let me file it so they can stop complaining, and I'm not at risk of foreclosing my response by missing discovery deadlines. Here he's saying, if I file the lawsuit, I'll have to corroborate it. And I think that speaks volumes. And I'll have to produce everything and prove it, you know? And, I'm not about to play around with the Southern District of New York, you know? They had me to hang already. So everything that I file is going to be double checked, triple checked, which is what I did. That's inconsistent. You're saying, I'm not pulling out of thin air. If I file, I'll have to prove it. SDNY has had me hanging already. So everything I file is going to be double checked, triple checked, which is what I did. It's like he caught himself while he was saying that, realizing that it could imply that he hasn't actually done this vetting. And then he goes, which is what I did. I wish we could hear the tone of voice. So, like it is what it is. And he realized he should stop talking. Erica says, so, going back to my question, what is your client looking for? I mean, is there an additional monetary demand, or is it the 2.6 that you make reference to? Blackburn, I don't think, yeah, the thing is, so the 2.6 that I made reference to in the complaint is just an estimate of what we believe the value of his lost services is. And that's absent in the audits or anything like that, right? This is just a guesstimation, a very conservative one, because we don't have the actual contract concerts. I mean, the show contracts or whatever it is. And, you have a draft complaint that you're threatening to file in 4 days and then in 1 day. And you're making representations to the court in the filing if you were to file that draft. Because remember, he waited till June to actually file it. Till after the process server thing. To me, it makes it seem like he had it locked and loaded, and that was the trigger. He gets this arrest, and he's like, oh gosh, well, let me put something else out there to counteract it. You haven't looked at the contracts? So what are you basing it on? Because you could represent in the complaint, you could say, like, look, an amount that upon, discovery or whatever, we would evaluate when we have that information. It's okay to put that and say, like, look, we need to do discovery. But he puts an amount in, and then when he's confronted with, why did you put that specific amount? He's like, it's a guesstimation. We actually haven't seen the contracts that we're saying we base them on. He says, and listen, let me just say this. I should have said this in the beginning. I want to just hit a reset because I don't want you to think that I'm coming across as like an a-hole. I've just dealt with a lot of real a-holes on the opposing side over the past year. Well, pot, meat, kettle, like, I can understand why opposing counsel might treat you a certain way. And your demeanor is not of that. So if I read your email wrong, the tone of your email incorrectly, I apologize for that. But, I get you have to defend your client and you're going to do everything that you can to make sure that he comes out on top. And I have to do what I can to make sure that my client's claims are heard. And he's made whole to the best of my ability based on the facts and evidence that I have and based on what we can prove. So, take no offense to the tone of my email. It was a response to what I thought was the tone of your email. But I don't just say that, right? So, Erica says, well, it was a very big, big, scary claim there. So Blackburn says, yeah, because, yeah, listen, your job is to deny. Even if there was, you would never admit it. I mean, please. I've had cases where I've literally shown a guy, look, this is your, he said, look, this is your penis and you sent this. This is your phone number. You sent this to my client. Like, I have it right here. He denied it anyway, right? So, it's like, so I get it. Like, I don't ever expect you to admit anything, right? You'll never do it. It's fine. Erica says, right. Blackburn says, I'm not looking for an admission, but I am looking to see if there's a possible way for us to reach a resolution, of this. And I think that we can, but again, the number that's inside of the complaint is it was a rough estimate based on a very conservative calculation that I put together. What did you calculate? And I'm no accountant, we don't have an economic expert. I don't have an audit. I don't have anything to show. Okay, well, these are the brass tacks. These are the raw numbers of what it is for everything, right? So, if you want, what I can do is I don't know. My computer keeps restarting. I'm sorry. That's what that beeping noise is. The computer's yelling at him. Erica's like, no worries, no worries. And this is indiscernible. Erica says, so that's, you don't need to give me, I guess, a number, but I guess I'm wondering, so you came up with that dollar amount just based on your conversations with this former manager? May I have that person's name? Blackburn says yes. So there's a guy named Mateo who I spoke with, and there's another gentleman, and I don't have my notes. I spoke with two former managers who had a lot of information. I can't find this other thing. I wish I had the name in front of me. I can get you the name of the other individual, and I will. Sorry. Email that over to you, and I guess. We can begin at some other time. Or I can send you over, what his opening settlement demand is. I don't know if your client has insurance. Apparently he does, because one of his managers said that he does have insurance for things like this or something like that. So I don't know, that's information that I received late last night, that he may have insurance. If he does, then great. If he doesn't, then, it is what it is. But, that's what I was told. Why would you invite an insurance company to get involved in a payout if you don't want to? He's saying, like, if I file something, then I'll have to prove it. Why would you want insurance lawyers to get involved? This is crazy. He's just rattling on. Erica's letting him talk. But I spoke with Mateo, and then and apparently there's a gentleman named Peter who owed Joe, and I believe, what's his name? It's just Ja Rule. Isn't that a Ja Rule line? What's my MF name? He says, what's his name? It's just Ja Rule, I think Ja Rule. Money or whatever. And, Joe set him up to be assaulted. And the guy ended up wiring him, I think, 150 or 200,000, and wiring Ja Rule another 150,000, So Ja Rule is just being implicated here. Erica Murrah says, this person's name is Teaser? Blackburn's like, no, Peter. Like, Erica's like, oh, Peter. Blackburn's like, yep, like Peter Pan. Erica says, okay. Blackburn says, these are just, do you have Peter's last name? Blackburn, I do not. Maria says, okay, yeah. Blackburn, I wish I took these names down, these last names, but Joe, I believe, from what I understand, Joe would know exactly who these people are when you speak to him and you bring this to them. Erica says, yeah. Blackburn, but what I want to do is I'm going to speak with my client. Erica says, yeah. Blackburn says, and send you over, a formal demand with a breakdown of what, damages we know he believes the damages are. And, you respond in kind, or, you rejected it, the whole claw, which I know you will. And then we'll have another conversation, and then we'll go back and forth and blah, 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 blah. So remember, he was saying in his deposition that these are all just requests for friendly conversation. Erica Morera, and you can send me the documents and, photos, evidence, so I can discuss with my client. Blackburn says, I will talk to him about that to see if he'd be willing to give that. I know Nikki has not given permission to turn over anything yet because she says she has to pray and meditate about this and speak to her husband and blah, 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 blah. So I don't know what her deal is, but Nicole, I'll talk to her and see if she's okay with me sharing anything. Morera says, okay. So in your March 23rd letter, you didn't make any mention of alleged sex trafficking and Jane Doe's. So I guess I'm wondering why it came up now. Blackburn says, because the thing is, when I spoke with my client initially, he did not share everything with me, as is the case with most of these cases. And, I'm talking to him and really digging down deep, and I'm asking him more questions. And as he starts talking, I'm like, okay, well, was there ever a time when you were left behind? He goes, yeah, I was left behind here, 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 and here. What was the reason that you were left? And he told me what the reason was. I said, okay, well, that's an issue because I understand the TVPA, and I'm sure you do as well. And we understand that, aspects of it does not require actual penetration or actual trafficking. One of the charges that one of my clients was able to bring against Mr. Combs, and I'm telling you, he's getting this idea. He's like, let's just take the ditty and move it to somewhere else and accuse somebody else of the ditty. Let's just say everybody's diddling. So he says, we understand that because, one of the charges that my clients was able to bring against Mr. Combs in his criminal case, and I believe it was the third indictment, was the fact that he required him to engage in sex acts even though he had already performed and had gotten paid for his sex acts. One of my clients is a sex worker, and the prosecutors brought a claim based on that charge, and based on those claims that he had stayed back and continued doing stuff even after his hour was already up. So, and Sean had stolen his phone and taken his clothes, and he couldn't leave until he finished performing the additional stuff that he was not compensated for. So when I learned that, I tend to ask everyone that now. Okay, well, was there ever a situation like this? And that's when TA told me, yeah, of course. That happened multiple times. It happened and it's indiscernible. The country's down, and the different states where it happened. And apparently he just told me today there was an orgy that happened in Norway at the Rolex Hotel, I think is what he said. And, he was in the room with the woman that he went to be with, about 22 years old. And, Joe asked him to come back into another room. He said he didn't want to go and he got left in Norway. So, that's another one that I did not put into this complaint. We talked about that today. So, my experience with these individuals when it comes to these kinds of cases is that especially when they have a decade's worth of experience working with a particular individual, things start coming up and they start remembering things as time progresses and time goes by. So it's not like, oh, well, March's letter was everything and everything that he said that he knew at the same time. It was not. Everything else subsequent to that was from him having continuous conversations and going through his laptop and finding things and pulling up things and remembering things. So that's where that came from. Oh my goodness. Marrera says, understood. So, my client would only settle because he's afraid, He, as I said, I'm sorry, and just going back to something you said previously, you said there was, like, this orgy happened at the Rolex Hotel, like the watch? Tyrone Blackburn. Yeah. Erica says, okay. Blackburn says, yes, the Rolex Hotel. I think it's in Norway. And I believe in that hotel, there was a lot of, the group. Some of this stuff is just really disgusting to even repeat, but it wasn't good. My client told me he estimates that they had sex with maybe over 4,000 women during that time frame, Can Bonnie Blue even pull that off? Is this possible? Of course, again, your client denies everything. I'm not asking him to admit everything, but that's just what he's saying. And there's just a lot. It's just a lot. It's a lot. It's a lot. Trust me, it's a lot. It's just a lot. Okay, how many times are we gonna say that? Erica says, right. Look, I've worked with a lot of artists and having sex is not a crime. So Blackburn says, I get that, but having sex with someone under 15 is. Erica says, of course. Blackburn says, right. So, I'm not, I'm not. Listen, I want you to be very clear. This is not about Joe's decisions in the bedroom with whomever he chooses to sleep with. This is business. This is about what he required my client to do and left my client in Africa, left my client in Asia, left my client in Europe when my client refused to do those things, right? That is the key. That's the part. If any part of the TVPA was going to be brought, it's going to be based on those things. Nothing to do with Nikki. I'm not filing on her behalf. I'm not filing on Nicole's behalf. I'm not filing on that Dominican girl's behalf. We don't even have a first name for her. I'm not filing on any of people's behalf. This is strictly about TA and the fact that, he was called in to, to perform in front of Joe during times when he did not want to perform. And, he was required to, to engage in these sex acts. He said in the Rolex Hotel, him and another guy was required to, like, have sex with on top of, like, pool tables. And Joe was standing back there watching and, like, recording it. So, it's just a lot, a lot, a lot. Erica says, and these recordings are in your client's possession? Blackburn, well, some of them are in his possession, and he does have them on a laptop and a hard drive, but I believe that your client may have some of them on his own and his own possession. There's a Marketing America. I don't know why it's in my notes, but it says, oh yes, okay, I get it. Okay, so there was a Marketing America in North Carolina. It was some sort of event that they'd went to, and my client said that he was dating this older woman. She was like in her 30s or whatever it is. She had a daughter who was 16, and Joe had asked the mom if he can have the daughter. And, the mom said, listen, she's only 16, and, Joe still pursued her. So that woman, who from that time in North Carolina, we haven't spoken to her yet. But I think my client is trying to find her, trying to find her and her daughter to, see if she would give a statement or whatever. So this means Blackburn has not vetted this out. He's saying it's just from Marketing America. What? Erica says, do you represent, so are Nikki and Nicole, are they the Jane Does that you refer to in the complaint? And Blackburn says, yeah. I think. So Nikki is number 3. I don't have the complaint in front of me. I think Nicole might be number 2, and the Dominican girl from the Bronx, I think, might be number 1. And then there are others who, like this one from Marketing in America. I've not put her in there. Okay. And then Erica's like, what is Market America event? That was something in North Carolina where my client was with a 30-year-old woman, or a 35-year-old woman, I think he said. And that woman had a daughter that was 16, and Joe liked the daughter. And the woman told Joe, no, my daughter's like 16 years old. And Joe was like, oh, no, I just want her to come to my room. We can talk or whatever. And, like the daughter went to the room and, Joe had sex with the child, well, with the daughter. So that was a North Carolina event. So I don't have the names of these people. I have not spoken to them. My client just told me about that today. So I just told you about it today. So Erica says, so you don't represent the Jane Does? And Blackburn's like, I don't represent them. No, they've not. Well, I'm going to tell you this straight up. They've not given any kind of indication that they had any interest in filing anything. Nikki says she has no interest in filing anything. She says she's a mother now. She's a wife. She has no interest. And Nicole neither has an interest in filing anything. She's also married to a baseball player. And she's living a very posh life. So she doesn't want to bring this down on her family or whatever it is. So I'm not representing them. I have not solicited to represent them, so that's what it is for those two. This is why I said to you that the only claim under the TVPA that I would have would be for my client. But these individuals are just, evidence of other prior bad acts or similar acts. So that's it. And then Erica says, so your client contacting these individuals is in order to strengthen your client's claim, correct? And Blackburn says, not really to strengthen his claim, but to corroborate, because I'm not going to put something in the pleading that I haven't heard myself. Erica says, mm-hmm. Tyrone says, like, you're not going to say, oh, Joe, killed a man and so witnessed it. Well, if so-and-so is still alive, I need to speak to so-and-so, who's going to confirm that he did, where I just lost my place. Who's going to affirm that he saw Joe kill someone, or else I'm not going to put it in that complaint. Erica says, mm-hmm. So, I made that very clear. Can you imagine being on the other end of this phone call? And like just hearing this on the other end? I feel nuts reading it. like I feel like I'm rambling, but I'm just reading. I'm just reading the transcription. My goodness. My goodness. Oh, goodness. This is just a lot. This goes on and on and on. I want to do a quick, hold on, let's see. I just saw a notification. Oh, I want to do a second live a little bit. I've been waiting for to see the filing come in Afroman. If you guys missed the news this morning, Afroman posted that he was suing Brian Newland for, the $400 and also for the lawsuit that Brian Newland participated in against Afroman. And I've been waiting for the full filing. It's 8 pages, and I just grabbed that. My brother actually sent the link over, which is very cool. It's like he knew I was looking for it. So just so you guys know, if you're watching this live, we might do an encore. And this is a lot. Hold on, we're on page 29. Oh, I've been nervous about my voice after I really lost my voice last week after reading the Zach Adams decision. All right, so some of these pages are just index. So we've got 12 more pages to go, right? Am I counting that right? We're going to do it, chat. We're going to get through it. And then we're going to do a quick Afroman thing. So give me one moment here. Let me share that. Do that in a little bit. All right, there we go. So that'll be scheduled. So we'll get back together. We'll finish this up. And if you want to come listen to whatever Afro Man says in his lawsuit against Brian Newland, we're going to do a double feature today. So, all right. So Blackburn says, yeah, he says, I'm not putting it in there until I hear from these people himself. And Erica's like, And Tyrone says, and he said, okay. And he's gotten me, like, for instance, the Marketing America. I said, I'll mention it when I speak to you, but I'm not going to put anything in the complaint about this until I hear from the mother and daughter myself. And only once I confirm what you're alleging, then I'll feel confident enough to know that I did my due diligence. And I can come forward and say what it is that they told me. Erica says, okay, so specifically, the event in North Carolina was a Marketing America event. Tyrone Blackburn says, yep. Mariera says, was that a performance? Is that... Blackburn says, I have absolutely no idea. So he doesn't know. I think it might be a company that your client is using that he used to do business with. I have no idea. Maybe a promotional entity. I don't know. I have no clue. Erica says, do you know, did he tell you when that happened? Like what year? Blackburn says, no. It was just like, he was like literally 5 minutes before you called me. He told me that, and I just jotted it down on the... And Erica's like, okay, got it. Blackburn's like, yeah. So I've not spoken to the people. I just figured that I'll, since I have it here in my little notes that I jotted down with him, I'll just raise it to you, just so you can, present it to your client, see if he remembers, if it makes any sense to him, if it rings a bell, like that's, yeah. So Erica says, do you have any dates for any of these alleged incidents, like the one in Norway? Blackburn's like, yes, well, yep. Well, right now, what he's doing is he's going through his cloud account to get me all of the past, to get me all of his trip tickets, his flights, and everything. Erica says, okay, Blackburn says, so once I get all of that, and I think he's getting his, I'm sending his laptop, because he has another laptop that's currently like, it takes forever to turn on, and it's not working and whatever. So I'm sending that to my forensics guy to pull all of the data off of it, because that has all of the flights, his flight tickets, and everything on that. And I'm probably going to contact TSA to check all of his travel, his passport stamps. Why don't you have Homeland Security, your friends at Homeland Security, check this out for you? Have them help you out since you know them well enough to make personal invitations. And then he says he has his passport, so I'm looking at his passport stamps and, his entry and exit. So I'm going to try to get an audit of that before anything is filed. And then I'll create a chart and send it over to you if you want. And you can see dates, times, places where he traveled, where he went, when all these things happened. Erica's like, yeah, that would be helpful to have this conversation with my client. I mean, these are very serious allegations, and he would only settle because he's afraid. He categorically denies these allegations, The allegations like this, as you know, can ruin someone's reputation, whether they're true or not. Yeah. So then Terrance says, no, listen, I get it, which is why I'm very careful with what I bring now. Because listen, I've had multiple people who approach me with allegations and claims against very, very powerful people. I had a couple of NBA owners, all kinds of stuff. And I did not bring those lawsuits because these people could not corroborate anything they alleged. But in this instance, I felt comfortable enough to send over the letter because he corroborated through conversations and through photos and through other things, everything that he's alleged. So, so that's the difference. I know your client categorically denies everything, as all defense counsel and their clients do. So I get it. But, I believe that what my client is saying, he's backed up and he's not been able he's not. And I promise when I'm reading this, I'm reading it as it's transcribed. I'm not just rolling over the words. He has not, there's nothing that he has said that he's not been able to back up yet. So, well, you just went through this whole spiel about how he can't show you anything on his computer because something that would presumably be an email correspondence, he needs to turn on a hardware device to show you the booking records. I mean, unless he's like deleting the emails and downloading a hard copy to his laptop. Sounds like a pain in the butt to do if your laptop's really slow. But here, Blackburn, 2 seconds later, is saying there's nothing that he said that he's not been able to back up yet. How do you know if it seems like he has an excuse for why you haven't actually seen anything he's talking about, that you claim he's talking about. So Erica says, so you say that the complaint is just the tip of the iceberg. So Blackburn's like, yeah, because there are other things, like the things that I shared with you right now over the phone. I mean, like, there's this thing where apparently there's someone doing life right now in prison. Apparently Joe grew up in the Mitchell projects. He was hanging around some individuals who were not, the best people. Something happened, and and someone may have lost their life for it. And somebody else is currently serving time for that incident that happened around the Mitchell projects that Joe was actually responsible for. And that happened before he became Fat Joe as we know him, right? I spoke with Cuban Link myself, and he told me about the incident in the club with the slashing of the face and all that stuff. And I spoke with somebody else who was also there that day when that happened. She's actually, Erica says, who is this? Sorry, who is this person in prison? Do you have a name? Blackburn said, my client did not want to give me that name. I begged. Trust me, I begged. Couldn't you research this and figure out who it was without having to beg? If you know the context of the incident, could you not go figure out who was charged and prosecuted for it? Erica says, uh-huh. Blackburn says, again, that's why I didn't put it in the complaint. Erica says, uh-huh. Terrance says, because again, I need to verify. If I can't verify, I'm not putting it in the complaint. But you put that amount in the complaint that you didn't see contracts for. Oh my gosh. Blackburn says, but he said if you mention that to Joe, Joe will know exactly what it is that he's talking about. I said, fine. Marrera says, uh-huh. Blackburn said, I spoke to Cuban Link myself. He's not my client. Erica says, mm-hmm. Blackburn says, I spoke to Cuban Link, and he told me about the time when Joe slashed him in the face. And he told me about, and not only did I speak to Cuban Link, because I didn't take his word for it either, I spoke with someone else who was there at the time, and that person is currently suing Sean Combs. Gloria Allred is representing her. And she said, yes, like I was there. She was dating somebody from Bad Boy at the time, and they were at some club or whatever, and she witnessed the entire thing as it unfolded, as it happened. Did he actually speak to these people, or is he just like looking? Because this conversation would have happened after some of the Diddy complaints already came forward and were filed. So is he actually like personal knowledge speaking with people, or is he just like taking details from public filings? Erica says, so the allegation is that Joe slashed Cuban Link in the face? Blackburn says, either I believe Joe set it up or Joe is responsible for it happening. It was one of those situations. How do you not know the difference? Erica says, okay. Tyrone Blackburn says, sorry, yeah. Erica says, mm-hmm. Blackburn says, yeah, okay, so, the thing is, listen, it just all aligns. And it's just all a buildup of the same or similar claim that, that Joe will get you taken care of if he feels that there's a problem. Hence why, my client felt the need to tell me about the threat. And hence why I felt the need to send you that email. Because, I take those things very seriously. Erica says, mm-hmm, mm-hmm. Blackburn says, especially after speaking to Cuban Link. So he said like 3 times he spoke to Cuban Link. And especially, and corroborating that, and speaking to the person that was there, that witnessed it, and corroborating that. And the fact that, he, according to my client, Joe told him that no one ever leaves Terror Squad unscathed. Look at Cuban Link. And apparently there's another person. Listen, man, I don't want to tell you, and just keep coming to you with all these different things that happened in the past. But it's just, it's just good context for you to have so you can know why my client feels the way he feels and why he, felt the need to, tell me, to tell you, what he knows, This is just, really, really unfortunate. I think this is something that can be easily resolved if there is, true transparency when it comes to these things. Erica's barely speaking, but she's just like, do you have this? Can you show it to me? Can you send me this? If you have this chart with the amounts, that would be helpful. Do you have these pictures? Do you have these videos? And here Tyrone Blackburn's like, true transparency. He says, I know your client thinks he doesn't owe him anything at all, and that all of this is just whatever, but, people say otherwise, say other. I mean, you have former managers saying, no, he does owe him because, the guy did all these things. Apparently, I don't know if it's Mateo or it's another manager, but there was somebody else who was sitting on a plane with my client. When my client edited and helped to, I think he edited and he did something to All the Way Up, which is that song that went very, very popular. And, the guy is ready to corroborate it. And he said that, if and when you need, I need him to come forward with the sworn statement, he will do it. He just needs to be subpoenaed to provide it. And I was like, okay, I would love to see how that conversation actually went down. Erica's like, Blackburn's like, you know what I'm saying? So it's just, this is just what, I don't know. Marera says, so if we do settle, what assurance do we have that your client won't go to Homeland Security? Blackburn's like, well, the thing is, you said that there's no threat. And the thing is, listen, no, I'm not, I just want to be very clear. I'm not telling you, give me $1 or I will go to the police and complain. That's not what I'm doing. That's definitely not what I'm doing. I'm, t- I'm telling you that he wants to be made whole for what he believes he lost. Whether or not if your client chooses not to pay him, it doesn't change the fact that my client is going to proceed and try to be made whole for what he believes are his losses, through his TVPA claims, as well as through the other claims that are articulated within the complaint, right? If I was on the other side of this line, I would feel like someone was trying to extort me or my client. I would feel like somebody was trying to extort whoever. That's definitely not what I'm doing. In the context of everything that preceded this, I think it's very reasonable. I think it's very reasonable to feel like this is an extortionate attempt. And maybe that's why he was so upset. Even though he's claiming he recorded everything with Erica, maybe it's why he's so upset that he found out that this call was recorded. Like, this is just wild. And I wonder, like, the word count difference between how much Erica's actually saying here versus how much Tyrone is just yapping. He's, like, yammering. Like, oh my goodness. So he says he wants to be made whole for what he believes are his losses through his TVPA claims, as well as through the other claims that are articulated within the complaint, right? The Homeland Security was attached to what we believed was a threat, what my client told me was a threat, and that's why I said that if a threat comes again, that our next move would be to go to Homeland Security. And that's something that I said, and that's something I meant 100%. Whether your client chooses to give him money or not, that's your client's choice. It's not, if he chooses to pay him, Homeland Security has nothing to do with that. If he chooses not to pay him, Homeland Security has nothing to do with that. But if he threatens him, Homeland Security is going to be all over that, right? And then it says indiscernible. Erica says, well, so your allegations are quite serious and they're reputation destroying allegations. My client's a hardworking guy who has, built a career here. And so I guess I'm just scratching my head thinking why there's, copyright allegations mixed in with human trafficking. I mean, it does feel a bit like a way of scaring and pressuring my client into a settlement. Blackburn, no, that's not what this is at all. The thing is, as well as I that if you don't bring all claims, then you're going to waive all claims if there ever is a settlement. But you just spent like 5 pages talking about how you aren't going to bring all claims for different reasons. And now you're switching. He says, right? And you have to bring everything you know now or you forever hold your peace. So I'm bringing everything that whatever claim, this is literally the spaghetti method. And it doesn't even need to be true and verified spaghettis. I guess spaghetti's plural already. He says, bringing everything that whatever claim that my client has. I said, you have to sit down and think about it. Whatever you think is the problem, whatever you're focused on right now, you need to take a pause, take a breather, and think of the full landscape of all the things you may deem as a slight. As a slight? Slights aren't specifically actionable. Bring it to my attention and I'll be the one to decide whether or not it rises to the level of an actionable claim. Okay, so he's saying bring it to my attention and then I would have to do the work to vet if there is like a legal basis and or veracity, truth, which is what he did, which is why the complaint is very different than what the letter was in March. Erica says, Blackburn says, so it's not a matter of, throwing in the kitchen sink. Oh, I put kitchen sink in the thumbnail. I didn't even know this was in here. Guys, go look at my thumbnail and look at the little text at the top. My mock case caption, my case name. I put Tyrone Blackburn versus the kitchen sink. So he says, it's not like I'm throwing in the kitchen sink. He says that he has copyright claims. Okay, great. He also says he has TVPA claims. Okay, great. He says that he learned that he was never fully compensated when he should have been compensated for the work that he did. Okay, great. Let's see if there's any way that we can bring any of these claims based on the date of discovery rule, based on whatever, and, and corroboration and confirmation from people that he called witnesses whom I spoke to. He was able to do it, so that's where we are. It has nothing to do with just filing anything just to file it. I mean, you're going to file your motion to dismiss, which is expected. I'm going to have to then file my opposition and provide whatever evidence I have to overcome that. Did we forget this over the last few months? Because I'm not sure we actually accomplished this part. And then we move forward. I mean, he forgot to depose Fat Joe. He just never set a deposition to depose Fat Joe. And then we move forward to discovery, and, that's just what it is. No one is trying to ruin or destroy your client's reputation. But, my client claims that he's been harmed and he needs to be made whole. Your client says he doesn't owe him anything. My client thinks differently, and that's what litigation is about. It has nothing to do with trying to harm someone's reputation. People are going to get harmed, that's the nature of litigation. So, that's why. But you just started this whole thing by saying you're not trying to harm anybody's reputation. You're just trying to make someone whole. Oh man, it's like so back and forth in his own words. Hey, you guys. Hey, Keisha. See Ray's in the building too. Allie's in the building. Kristen's here trying to hang on. I looked over and I saw the index. Hold on. Okay, we are on page 41. Oh, yeah, has a lot. Whereas Oh, is that a joke? Or am I missing it? Okay, that was a joke, but that's funny. Right? There's a lot of yeahs. Oh, no. Okay. Let's go to K. Okay, this must be it. Look at this right column. It says no. Oh, new has a mention here too. Holy moly, look at the index here for how many times no is stated. Oh, goodness. Hilarious. Hilarious. Oh, I don't even remember where we were. I highlighted it. That was like 41. Okay. Okay, so then he's like, that's why we're having these conversations. We're trying to avoid that piece. And again, Homeland Security has nothing to do with it. That was just only brought in because of what my client perceived as a threat. So, and then Erica says, okay, so understood. So I think you've promised to create a chart with some information that I've asked for. Blackburn says, Moreira says, you will check in with your client and the witnesses about sending the photographs, videos, whatever it is that exists, so that I can have a conversation with my client. Is there anything else? She's like, I gotta go. I gotta get off of this. Blackburn's like, no, that's it. So what I'll do is I will speak to him, tell him that we've, give him a little summary of what we talked about, see what his demand is, send that over to you under, the regular, normal, settlement communication email. And, if your client is interested in going to mediation of some sort, that's something we can possibly do. I can, try to give you a list of mediators that I think would be feasible. There's a couple in JAMS that I think are good, former judges, former appellate judges. There's a Spanish guy who I think is extremely good. He's from the Bronx, so he understands, I think he would be really exceptional because I think he understands the community. I think he'll understand the parties. And then indiscernible. And then Morera's like, what's that person's name? And he says, his name is, God, Judge Belline, Belene. He's in jams. He's a former appellate judge, Judge Belline. Let me just look it up real quick. Morera's like, okay. Blackburn spells it again, leaves out the E. It's Ariel Bellin. And then Morera says, okay. And then he's still spelling the name. It says he's retired. He's a Latino judge, a former New York State appellate judge. Morera says, mm-hmm. Blackburn says, went to Cornell, all that stuff. So a very, very smart guy, a very patient guy. I've mediated a couple of cases with him. We started at 8 in the morning, and he legit mediated until 12 midnight a couple of times. I wonder how much talking. That's a long time. Erica says, mm-hmm. Blackburn says, because he refused to get off until the parties resolved it. So he's good. Very persuasive. He will... Do, do you want a mediator to be persuasive? He doesn't mind getting up in your face, telling you when you're wrong, like he's good. So that's the one guy that I think would be fitting for this because he speaks the language, he understands the lingo, he gets people. Yeah, you went from language to saying he's great because he's persuasive and won't let it go until things settle out before litigation has to proceed, which seems to be the whole thing earlier in this call you're trying to avoid because then you'd have to prove things and provide the things that you said you have. So maybe there's a reason you really like Balin, and it's not just because he's a Latino judge and went to Cornell. He said there's another one, he's not Latino, but he's a retired judge out of Newark, but I've been able to resolve everything with him as well on my New Jersey cases. I forgot his name. Is it Doyle? No, Doyne. I think it's Doyne. Doyne. Hold on. Is it Doyne? Erica's like, okay. Blackburn's like, Peter Doyne. Yep, Peter. Peter, Doyne. Peter, yep, Peter E. Doyne from Farrell, Labella, and Weiss. And he's a retired judge. He was the assignment judge for the state of New Jersey, very, very high ranking, appointed by the Supreme Court to oversee the selection of judges for the state. He's beyond thorough, He's lights out, probably an equal footing as Balin. And I think more persuasive than Balin in the same sense that, Balin, I don't think was ever. I think Balin was in the trial level, but not for a long period of time. But Doyne had been on the trial level throughout his entire career. He never went to the public level. So he understands a lot more because he's more close to more recent, civil litigations. And he's able to really talk to the ramifications of both sides. So, those are my two. I'll put them in an email for you so you can have them and you can, talk about it, talk it over with your client. Again, like I said to you before, I'm not trying to, harm your client or do whatever. Like, that's not my goal. Even though that's what, the PR people try to spin it and say that I'm just a, monster trying to hurt everybody. That's not, oh. So you mean you had this reputation for this before the incident you said gives rise to your defamation lawsuits that you're filing, 3 different lawsuits that you're filing in relation to the process server incident? You already had this reputation? He said, that's not my goal at all. These conversations are necessary. And, because of all the scrutiny that I'm under, I'm even more careful now before I bring anything. So, like I said before, I've been able to corroborate all that my client is raising, and I think that I've met my bar as counsel before filing. So, yeah. Oh boy. So I will leave you, send over that email, speak to my client, and we can probably reconvene early next week if that works for you. Erica says, yeah, if you can get me some, more detailed information in some of your sources and source materials, then I think that will help us have a conversation. And, the more you can get me, the better it will be. Blackburn says, okay, and if you have some mediators that you like to, you let me know. I don't have a problem with that. Marrera says, sure. Blackburn, it says indiscernible. These two, So, and Marrera says, sure. Blackburn says, all right. Marrera says, okay, thank you, Tyrone. Blackburn says, okay, all right, no problem. All right, bye-bye. And Erica says, bye-bye. No wonder he was pissed that this was recorded. No wonder he was pissed. I think this looks horrible for him. If I was his client and co-defendant in a defamation case that someone brought against me for the claims. From the position of the client, I think this would be a gold mine for me to defend myself. He's representing this stuff on a phone call. I didn't authorize him to do this. And he's even saying in this transcript, he doesn't want me doing this. He doesn't want me doing these communications. He's not acting on behalf of, Blackburn's saying he's not acting on behalf of his client. He's saying his client didn't want him to have these conversations. Like this is crazy. And this is why he was flipping his lid about, she should be criminally charged. She was illegally recording me without my consent, whatever. Even though we're representing in an email. He said in an email on his own, somewhat braggingly, in my opinion, that he's recorded every conversation himself. We pulled it up earlier. It was one of the exhibits. I don't know if I still have it open. But yeah, just wild, wild stuff. Wild, wild stuff. And I never want to say the phrase, you know, again. I need like a week-long break from the phrase, you know. But I think that wraps it up, guys. We made it through. Again, we didn't go through the exhibits that are just like repeats of filings from earlier in the case. Like we didn't go through the. Are these still the same exhibits or are these different exhibits? Let's just see this transcript real quick. I think this is just going to be. Yeah, so this is the excerpts that we previously read. See, it was filed March 24th. So we did a stream where we read through these available pages from the Terrance Dixon deposition. Remember, every couple pages it was jumping, like 10 pages would be missing. So some of it's confidential, filed under seal, but it doesn't look like there's anything new here. And then everything else is a copy of the complaint. And we didn't read the affidavit, the affirmation from the process server, but we saw the purpose it was referenced for, you know. Tried to service. I believe he was trying to evade service. He reversed. He hit me in the leg, whatever. So, my goodness, you guys, this was a lot. This was a lot. Oh my goodness. Hey, Adventure Aaron. And then Thriving Hippie Witch says, I'm new here and I'm watching the boat trial. We are, if you're interested in the Antonio Brown case, it's the same judge. So I'm following that case. So if you want to see more Miami-Dade trials, come hang out with us for Antonio Brown. I don't know if she's going to have the same restriction on the live chat feature. Hope you're enjoying the Pinot trial. What we're looking at is a hot mess. It's hard to understand, but in short, there's an attorney named Tyrone Blackburn who, not just public opinion, there's been sentiment that he chases settlements and brings lawsuits without fully vetting them, hoping to seek monetary settlements from individuals. And in the context of these cases, he recently sued lawyers like Joseph Tacopina, which I don't know why you'd want to initiate a fight like that. I think Joe Tacopina, kind of a bulldog attorney, he's not going to back down. He's going to put up a fight. And his team is really well-rounded and I think going to advocate for him very strongly. And in addition to that, I think Joe Tacopina, it's a defamation lawsuit. The statements he gave that are supposedly defamatory, there's like video where I think any reasonable person that watches the video could see why Joe Tacopina would say what he said. So it's such a huge rabbit hole, largely in my interest centering around the Fat Joe and a former hype man that had issues back and forth, and the litigation that ensued because of Tyrone Blackburn. I don't know how to explain it in detail without saying there's a playlist in the description if you want to dive into the rabbit hole, go all the way back. But just know it's a hot mess, and it's an attorney that it seems like every few months there's a new order coming down or finding from some court somewhere that the same attorney, Tyrone Blackburn, using AI hallucinations, not properly quoting things, misrepresenting case law, issues with Rule 11 where he's not vetting information before he files a lawsuit on behalf of a client, missing discovery deadlines, and it spans across multiple cases. It goes beyond my focus point of interest with the Fat Joe accusations. It's just crazy to the point where if you're coming into this and watch one stream, I wouldn't be surprised if you walk away like, how is this guy still a lawyer? And a frequent argument raised by opposing counsel, Tyrone Blackburn's opposing counsel, is look, this court, these other courts have admonished Tyrone Blackburn previously, and that has not deterred his behavior. You got to do something that deters this behavior. It's not appropriate. So it's wild. It's wild. Aaron says it's bliss to not know. It's bliss to not know the difference. Guys, that gets us caught up. I know we didn't do like a comprehensive reading on the 3 individual defamation lawsuits, but we did get to look at the claims as they relate to Joseph Tacopina. I would imagine there are, we saw some language in the defamation lawsuit filed against Joe Tacopina that seems more applicable to the process server. So I really don't know if the 3 different lawsuits would be all that different in substance. So I don't know if we're going to do readings on the individual ones, but we did get the gist. I think the important context of somebody went to TMZ, said that I hit this process server intentionally, and I'm saying that that's defamatory. And I disagree with that characterization. We'll see what the court does with it. But other than that, guys, I've been waiting all day to see the actual filing from Afroman, another Joe, Joseph Foreman, lots of Joes today, in relation to his new lawsuit that he filed against Brian Newland. So I'm going to take a break and rest my voice. I'm going to restrict my live time. Let's do 2 lives today. Take a little break here and then come back around. We'll get about the hour, so about 22 minutes here. I'm going to fire up a different stream. It's a short filing. I think it was 9 pages. We're just going to see what he's looking for, what action we're bringing against Brian Newland by Afroman. And it's filed by his same attorney that we saw at trial, Mr. Osborne. So let me set up a redirect there, carry us over if you want to come hang out. And all right, so that should redirect automatically. Whew, and there we go. And a big thank you, as always, /star. I don't always see you pop on YouTube. Always good when you do. But thank you for always when you notice, not just with this case, but, a lot of the Georgia appeals case updates. You're like, oh, there's an update. So thank you so much, not just for noticing things, but making it accessible, always going out of your way to share. I think it's so important. It's not easy to figure out where to go check up on what's going on with the case. It's time consuming even when you know where to go. And then it's also just easy to slip mind. So for multiple reasons, I appreciate very much that you do that. Especially you have a similar interest in cases like a lot of us here do as well. For everyone else that's hanging out in the chat, thank you for spending your time here. Thank you for, I hate when I don't go live for a little bit, and I hate when I'm like, I said I would do a live, and then another filing comes out, and we haven't done a live yet. So sorry about not going through those lawsuits. But I think, suffice it to say, I think we are caught up with enough context here. I think we're looking pretty good. So as far as this, process server defamation lawsuit, I'm assuming that in the other cases, there will be some response filings coming in as well. Maybe those will be interesting to look at. I obviously want to see what goes on between Tacopina versus Tyrone Blackburn. And then, of course, back over in the actual Fat Joe cases, the cases that really gave rise to this process server need, waiting for Judge Jennifer Willis to issue her written ruling on the Rule 11 sanctions motion. And then also to see what happens with the motion to withdraw. And while I don't doubt that the motion to withdraw is going to be granted, I'm curious to see if there's going to be any, I'm going to let you withdraw because you cannot continue as counsel for Terrance Dixon, but we have some problems we need to address. So I'm waiting to see how that stuff plays out, and nothing's come down on the docket yet. So other than that, you guys, if actualizes, see you in a few. I'm glad we pushed it half an hour early. That way you don't need to go to sleep. You'll be able to catch the whole thing. So see you guys in 20. We're going to talk about the Afroman case. And if you don't come hang out for that, take care. See you next time. Bye, guys.